My lady, so just my learned friend, Mr. Nkukatoivi, sent a message to me. He's on his way to court, but he said he's caught up in unexpectedly heavy traffic somewhere on the highway. He will be here in about 10 minutes or so. His team is present, and we may continue.
Yes, Mr. Naloni.
Ladies, good morning. We represent the first respondent, the Minister of Trade, Industry and Competition, who has been described in many terms: the decision maker, the ultimate decision maker, and that the buck stops with him. That is our client. But may I just make this remark at the outset that transformation in this country is a non-negotiable. It is written in the DNA of this country. It is also embedded in our social contract, the Constitution. It is not a nice to have. It is something that we are enjoying the society to have, because our past, future are built on the recognition of the injustice of our past, and we honor those who suffered for justice and freedom in our land. That is in our Constitution. That is our DNA. May I start by just outlining in brief the topics that we intend covering, and the respondents have had a discussion about how they wish to divide up the time, and we'll deal that in due course. But these are the main points that we want to make. The first point is that the process which the minister followed, when I refer to the minister, I'm talking about the DTIC minister, is lawful. It has followed the strictures, the requirements of every legal instrument that governs the powers, functions, and goings-on of the minister. So that is going to be our main point. And we will go through the record in some detail to illustrate where the minister confined and did his role as constitutionally and legislatively required. May I also make this remark that this is not the minister's code. It is a legal sector code. And I think once we characterize that, it shapes our philosophical approach to the role and functions of the various role players who are key to this process. I characterize the minister's role as that of a midwife. Baby must be conceived, gestation, and then at some point the baby must be delivered. The minister is a midwife. And the midwife must make sure that the baby is healthy, in good health, and can survive the rigors of life outside the mother. And we characterize the role of the minister as such. And so, in looking at the architecture, the legislative architecture, one must bear those in mind. That's how we view the role of the minister. We'll also deal with another point, which is very important, which is the following. The code is voluntary. If you don't like it, you don't need to have it. If you don't want it, go do something else. There is no legislative sanction. You don't comply with the code, it's your choice, it's voluntary. That is very, very important to bear in mind. And we will demonstrate through the record that the process has been followed. If I may make, before I start with going through the records and the papers, when I thought about this case, it reminds me of some historical facts that I've read and came across in my youth and as I was growing up. Studying the South African history, we all know there was something called the Anglo-Boer War. History has corrected that to say it's a South African war. It was not the Anglo-Boer War. But we know from our history that there's been colonialism. The English were the colonizers in this country. And our Afrikaner compatriots fought against colonialism by the Brits. Our founding father, Nelson Mandela, writes somewhere that when they started Umkhonto weSizwe, they looked at all kinds of experience in the past, and one of the things they learned was from the African compatriots. They launched an armed struggle against the Brits to fight against colonialism. Now, one thing that the Brits did was to do a policy called scorched earth policy to break the back of African resistance. They torched all the farms and made sure that Afrikaners did not have farms, did not have places to stay, to feed their kids, and to have the horses and oxen with which they could wage the anti-colonial struggle. Scorched earth policy. And another thing in simple terms means if we can't have the land, then we'll scorch it to the earth. We will burn it until you are expelled from the land. And this is what the English did to the Afrikaners. They said, we will scorch the earth. This created what was called then the poor white problem, because Afrikaners were landless, they wandering around the streets, and of course they formed themselves into a political formation. And we know that the National Party was a party primarily to take care of the poor white problem. They won the elections in 1948, and they built institutions which would benefit, uplift their people, the African people. Created banks, created big law firms. We had work from the big banks, Volksgas and others, to solve the poor white problem, which was created by what? The scorched earth policy. Here we are today, the black legal practitioners. They too have been the victims of scorched earth policies. There's a matter of historical matter which we all know, and here they are saying, we need a place in the sun. The applicants are saying, we want our code. We want our transformation charter. We want our own transformation charter, which we think the minister should have produced, which we think the minister should have applied his mind in this way and that way, which we say he should have not gotten rid of bursaries for black students. But that's their view. And the architecture of the imposition and development of a charter is that everybody is taken care of. Everybody's views count under the sun. Everybody has said their say. The applicants participated, which I'll show in the record, in the entire process of forming the legal practice code. They made comments. They had certain, as they should, concerns about certain structures of the code, which they articulated in the various stakeholder meetings, even to the ministers as then. Today, yesterday, they are rehashing arguments. They are rehashing issues which they had an opportunity, which the law, the architecture of the system allows for them to have done so. They are not asking the justices to say they must come to their aid. They must agree with them. The majority of the legal practitioners who signed off and supported the code have other views. This is not the code-making process. The court is not here to decide who is right, who is wrong. The process is gone, it's done and gone. Not only that, the structure of the code has created a new structure altogether, which is a mini-regulatory issue, institution on the code. I must confess, reading through the code is a very elaborate, it's not an easy thing. The stats, the targets. So we have a specialist body whose function it is to make sure that all of us, as practitioners to the system, they help us to interpret it, not only that, to execute it, to make sure that it becomes real in life. And that is the architecture of the system. But back to the voluntariness of it. If you don't like it, leave it. We shouldn't be sitting here and convincing the court that, no, the code should have been structured in this way or the other way. That is not the function of this court.
Should the court have regard to the lawfulness, whether this code was was developed, or rather, was published by the minister within the constraints of the legislation?
That's the first part that I'll deal with. We'll look at the legislation and how it dovetails with the various codes of practices and the guidelines which are meant to give life to. But the point I'm making is that the applicants don't have to apply the code. They can stick with the generic codes, which your leadership yesterday remarked that, of course, according to the record, they say they are compliant, and there's nothing to gainsay what they're doing. They are complying with the generic code, and the generic code has not been abolished. It is still there. If you want to comply, you can comply and go tell your clients that I comply with the generic code, and you can get your work on the basis of the relationship which you have with your client and the commercial agreements which you have with. But now to come and say it is unlawful, we don't want it, it is irrational, it is unreasonable, it sets impossible goals, it doesn't achieve what it's meant to do. And you say the minister did not even read it. So this thing, he didn't even apply his mind to it. So you don't like it, you don't have to comply with it. That's the point that you're making about the voluntariness of the. Now, if we can go back to basics about the legal structure as well as how this was brought about. Of course, this is about lawfulness. Did the minister act lawfully or not? Of course he did. He has a duty. Section 9 of the Constitution says it is imperative. Equality is an imperative of this country. Not only in form but in substance. It is not only a form that you are all, of course, in principle, all equal before the law. But we know that in real substance, we're not. And we know that even gender is a big issue that plays a dividing role in our country. Section 9 and other provisions of the Constitution says you must put in place measures which recognize, one, that some people in this country have been discriminated against by past practice. Black people in general, women particularly. If human beings were as good as we think they are, we would not need laws. They would do the right thing, they would empower others, but we know that's not how it works. That's why we have the courts as well.
Sadly not.
So, this is what the minister does. The minister says, the Constitution enjoins me to do certain things, and not only does it do that in the Constitution itself, it has mechanisms. It says, you must pass measures and laws. There can be no doubt whatsoever that the code is a measure contemplated in terms of Section 9 of the Constitution. And then, because of the subsidiarity of laws and implications, you can't rely directly on the Constitution to enforce and make sure that the laws are done and society is changed. An instrument has been put in place by the legislature, the Broad-Based Economic Empowerment Act 53 of 2003. It is in the in case lines. I can't recall. Yeah, or in fact, our learned friends were kind enough to give a hard
Yes, we
copies.
did get the hard copies.
Thank you. They just forgot about me. So the preamble is very instructive because it says preamble. Whereas under apartheid, race was used to control access to South Africa's productive resources and access to skills, whereas South Africa's economy still excludes the vast majority of its people from ownership of productive assets and the possession of advanced skills. Whereas South Africa's economy performs below its potential because of low level of income earned and generated by the majority of the people. And whereas unless further steps are taken to increase the effective participation of the majority of South Africans in the economy, the stability and prosperity of the economy in the future may be undermined to the detriment of all South Africans irrespective of race. In order to promote the achievement of the constitutional rights to equality, increase broad-based and effective participation of black people in the economy and promote higher growth rate, increase employment of more equitable income distribution, and establish a national policy on broad-based black economic empowerment so as to promote the economic unity of the nation, protect the common market, and promote equal opportunity and equal access to government services. Underline government services. It is a matter of fact that the majority of black legal practitioners do not have access to private work which is dished out by established institutions, banks, big companies, and all that. And their means where they can survive is mainly through government services, because government is the biggest spender, and so logically, that's where most black practitioners would go to. Not only government per se, but also state-owned enterprises, which enable them to eke a living.
That's because of the procurement policy.
Indeed, but that procurement policy is also based back on equality and other provisions of the Constitution, which says, unless you distribute wealth fairly, some people will remain victims of the scorched earth policy. And then if we go to the structure of the Act, of course there are definitions, then objectives, which are set out in paragraph 2. And 2B, D says, increasing the extent to which black women own and manage existing new enterprises, increasing their access to economic activities, infrastructure, and skills. And then 3 deals with interpretation. 4 deals with the establishment of Black Empowerment Advisory Council. Another Defense for Solidarity spent some time on this council, but in our view, it has nothing to do with what we're dealing with now. It is something else because it's function.
Just ignore. The minister do not need to comply.
Yeah, then we don't need to spend time on that.
Now, I just want to make sure the minister does not have to comply with Section 5.
Section 5, function of the council. Well, that's the council. So the council advises him, and he can either agree or not agree with them. But it's an advisory council. It makes broad policies and advice on matters of black economic empowerment generally.
And would it be for the minister, if he thought necessary, to then ask for assistance from the council?
Yes, he can. Let's see who the members are. In 6, is the president with the chairperson of the council, the minister, director general, 3 other cabinet ministers appointed by the president with their respective director general as alternates, not more than 10 or 15 other members appointed by the president. So
when appointing, but that is the minister's prerogative, is to have appropriate experience, the people that are appointed.
Indeed.
That is 2A and 2B, to represent different relevant constituencies, including trade unions and so forth. But that would be for the president to decide. So I am just trying to understand, because before it was raised yesterday, it was not a point that I pertinently had. I'm trying to figure out where it fits in. So it is the minister's prerogative to ask advice from this council. It is not a must.
No. And also the reference to trade unions and business committee at 2D, 2B is to have as wide a representation of the cross-section of the community as possible. But this is not a sector code. A sector code is specific to a sector. So another for the solidarity, they are confusing this and the other sector-specific institutions. So this is because they are a trade union, they want to jump into this court because, as you asked yesterday, why are you here? And so they had to try and claw back. One of the things that they just see the word trade union and they think, voila, we're in. But it's not, it doesn't work like that. Because this deals with policy generally, and then we'll then, as we go along,
Should that fit in with the generic code, for instance? Because the generic code is not sector specific. So would that be an instance where this advisory council would, well, maybe I'm speculating.
No,
Maybe
they can give advice, saying, we need generic codes, for instance, and these are our views, but that's how far they get. The mechanics of creating those things is not within the council. It's the minister's prerogative and function. And if one looks at 9, that's where the minister's role gets sharpened. In order to promote the purposes of the Act, the minister may, by notice in the Gazette, issue codes of good practice on black economic empowerment that may include A, the further interpretation and definition of broad-based black economic empowerment, and the interpretation and definition of different categories of black empowerment entities. D, qualification criteria for preferential purposes for procurement and other economic activities. C, indicators to measure broad-based black economic empowerment. D, the weighing to be broad-based black empowerment indicators, referring to paragraph 6. E, guidelines for stakeholders in the relevant sectors in the economy to draw up information charters and codes of good practice for their sector. And we know the generic codes, the codes of good practices, they were developed before Minister Tau took office, from the time of Minister Davis. And this was in furtherance of Section 9. But for our purposes, E is critical, because we know from Statement 3, it fits in snugly with that. Guidelines, and the word guidelines is instructive. It carries through. For stakeholders in the relevant sector of the economy to draw up transformation charters and codes of good practice for their sector. This is where I say the minister is a midwife, and the stakeholders are the parents. And then if we go to 9.2, which is a matter which has provoked a bit of controversy, 9.2, a strategy issued by the minister in terms of Section 11 must be taken into account in preparing any code of good practice. So, two things. One, there must be a strategy issued by the minister in terms of but if one asks the question, which we'll elaborate on it, what if there's no strategy? But we'll come back to that. But 9 talks about a strategy.
Is it in peremptory terms?
I'm still dealing with 9.2.
Yes,
the
I'm just
peremptory part.
asking,
Yes.
because there's a must. Is it peremptory?
You know, usually a shall is more stronger than must, but it places an obligation on him. And the question I'm going to ask, what if there's no strategy, for a matter of fact? Does it mean the whole machinery of black empowerment must stop? Let me just do some housekeeping. Yesterday, our learned friends did say that there is some strategy, but that the strategy precedes the act.
Yes.
For the act says we must have a strategy, we must create one. We have uploaded, and we recall that in his answering of the Minister Tau said, there's a strategy is somewhere on the website, so it's publicly available, and we searched. We have located that document. We have put it on the in case lines.
Could you just give us the reference?
It's 19-968.
And is it clear from that when it was published or when it was brought about?
What is clear, it was before the act. But we will deal with this point little. Let me just give the court an indication of where we're going to argue the point. That as a matter of fact of the strategy, BE strategy, it may or may not have preceded the act. But when the codes were developed, there was a strategy. Whether that strategy fits in with what Section 11 requires is a matter between the minister and his boss, the president, whether he has fulfilled his functions in terms of what his legislature is required to do. It is not a matter which the stakeholders need worry about, and we'll elaborate this further. Because a strategy is a broad vision. It is not a code, it's not a guideline. It just says, as a country, we need to transform this country. We need to focus on certain areas of our economy and those who have been disadvantaged. It's a broad vision. But was there a strategy? Yes, it was. Does it comply with Section 11? Maybe, maybe not. But it doesn't take the matter further in our view. And we'll come back to that point. So Section 9 lays down the principles that codes of good practice may be developed. We know as a matter of fact, so we can tick 9. There's been compliance with 9. Because we know we've got we've got codes of good strategy, of good practice. And then we go to Section 9.3.3. A code of good practice issued in terms of Section 1 may specify targets consistent with the objectives of the Act. And we all know objectives is to create empowerment and make sure that those who have been in the periphery and the margins are brought in. Some of the youngsters, there's a song that youngsters like, they say, make the circle bigger. So that's the whole, make the circle bigger, not smaller. And B says the period within which those targets must be achieved. And subsection 4 says, in order to promote the achievement of equality of women, as provided for in Section 9.2 of the Constitution, a code of good practice issued in terms of Section 1 and any target specified in Code of Good Practice in terms of Section 3 may distinguish between black men and black women. 5, the minister must. This is where it gets interesting. What must he do? Before he issues replacing or amending a Code of Good Practice in terms of Section 1, publish the draft Code of Practice of Amendment in the Gazette for public comment. We can tick yes for this.
That was done.
It was done. Minister Patel, this process precedes, and when we come to what Minister Tawi had with him when he became the new minister, we will show that he was given a detailed memorandum because he did not need to do this. It was done already. And then B, publish a draft code of practice or amendment in the Gazette for public comment. The draft code has been there. He didn't need to do anything else. So that can tick. And then B, grant interested persons a period of at least 60 days to comment on the draft of code of good practice or amendment as the case may be. And that is why you see this court full, because some of the interested parties, they commented on this. Black Lawyers Association, all kinds of, so there has been proper compliance with 5B. Minister Tao finds a train, well, to use the midwife scenario, the baby is being born. Now he must come and deliver. So he can't say
Be born. Already been born.
no, not yet. He must
It's a
deliver.
full term.
The full term deliver.
He must deliver.
He must deliver. Yes. And that's what he did. And then 6 says, if requested to do so, the minister may, by notice in the Gazette, permit organs of state or public entities to specify qualification criteria for procurement and other economic activities which exceed those set by the minister in terms of subsection 1. We'll see when we go to the memorandum that the state organs were also consulted during the process of developing the code. And even I go back, there's a question which Justice Passon asked yesterday, and the question was, the minister comes into office, he is given a briefing, and then a month or two later, he then gazettes. And the question was, what did he do in that period of time? Did he consult further? Well, the train had passed. He could consult because the code were published, there were comments, they were revised, then found. He only had to deliver. He can't then say, let's redo this thing.
It's already been done.
It's already been done. And so he doesn't need to consult anybody. It would be unfair to the people who, in the last 2-3 years, have been commenting, attending meetings, and whose comments were taken into account in the further development, for the minister then to consult somebody else. Who does he consult? He can't consult his friends. He has consulted the sector. But that has been done already. So there's nothing else for him left to consult. And then 7 says, a code of good practice remains in effect until amended, replaced, or repealed, which is what is the case now. We have a code of, the code of good practice there. It has not been amended yet. Now we go to the status of codes of good practice, section 10. Every organ of state or public entity must apply any relevant code of good practice issued in terms of the Act in determining qualification criteria for the issuing of licenses, concessions, or other authorizations in respect of economic activity in terms of any law, developing and implementing a professional procurement policy. C, determining qualification criteria for the state or state-owned enterprises. D, developing criteria for entering into partnerships with the private sector. And E, determining criteria for the awarding of incentives, grants, and investment schemes in support of broad-based economic empowerment. Now, 2A, we get, that's where the minister now comes in. He may, after consultation with the relevant organ of state or public entity, exempt the organ of state or public entity from requirement contained in subsection 1, or allow a deviation therefrom if particular objectively verifiable facts or circumstances applicable to the organ of state or public entity necessitate an exemption or deviation. B, the minister must publish the notice of exemption or deviation in the Gazette.
That is not what we are dealing with in this application.
Indeed. But what we need to, so this is the codes of good practice. It is not transformation charters. We'll deal at 12, that's when, so these are the codes which says, these are the weightings, broad outline. So we're not yet there, we're not there. And then 11 talks about a strategy for broad-based economic empowerment. The minister must issue a strategy for broad-based economic empowerment. B, may change or replace a strategy issued in terms of the section. If I may just stick here for a moment. Our argument is that this is the minister's obligation.
And it's once again peremptory. The minister must.
Yeah, but it's on him.
Yes, no. But I say it is peremptory.
Indeed, yes. And then it says to a strategy in terms of the section must provide for an integrated or coordinated uniform approach to broad-based black economic empowerment by all organs of state, public entities, the private sector, non-governmental organizations, local communities, and other stakeholders. B, develop a plan for financing broad-based black economic empowerment, including the creation of incentive schemes to support effective black ownership, black-owned and managed enterprises. I'll look for the reference later in the strategy document itself, where it talks about financing, because this is one of the elements that must be there. The question is, if the strategy was there already, and it deals with financing, sometimes we may ask for things. If they are there, they are there. You know what it takes to draft a strategy for a government minister to draft a strategy. You must have it commented, must go to Parliament, and things don't change as quickly as we all want to. The fact that black people in the main are still disadvantaged economically, you can write a strategy document every year. That fact won't change. And so to insist on a strategy for the sake of insisting on it may not, the question is for what end? And then that's 11A, to the strategy, and 2A tells you what the strategy must deal with. And C, provide a system of organs of state, public entities, and other entities to prepare broad-based economic plans and report on compliance with those plans. In other words, you'll say to, as a minister, you say, you organs of state, you must support and maintain and promote broad-based economic empowerment. This gives them the power to do that. But also it says you must have plans. The strategy says you must have plans, because you can desire something, but if there's no plan on how to get it, it will be useless.
Just a moment. The ladies that are having a conversation, kindly do it outside court. They are distracting my attention. Mr. Nalani.
Thank you, Malini. And then be consistent with this act. If we go to section 12, which really is at the heart of this case, it talks about transformation charters. And it says the minister must publish in the Gazette for general information and promote a transformation charter for a particular sector of the economy. So,
what is the difference between a charter and a code?
the code, well, I think they are used interchangeably.
Because Section 9 refers to Code of Good Practice, and if I understand the papers correctly, but you must help me if I'm wrong, and the heads of argument, I was under the impression that the Minister was issuing or publishing this sector code under Section 9. So is it under Section 12 or 9?
It's 12.
12.
So 9 is a broad, it's a broad-based environment. It creates the environment for publishing codes of good practice, which would apply to all and sundry. Excellent.
So this is a charter, a transformation charter, not a code of good practice.
Let me, I'm being so the legal sector is called Broad-Based Black Economic Empowerment Legal Sector Code of Good Practice in terms of Section 9(1) of Broad-Based. So the code is called the Legal Sector Code.
Yeah, but that's why I want to know, you are referring us now to Section 12.
Yeah.
And I just wanted to make sure, because my understanding certainly all along was that this is in terms of Section 9.
Yes, 9 says, if you say 9(1), in order to promote the process, the minister may, by notice, issue codes of good practice. And we know the codes have been there. And those codes would include, if you look at the codes, it talks about the interpretation, qualification criteria, so it's broad in terms of the requirements.
Mr. Nalani,
Yes.
if you have regard to the minister's, what was gazetted by the minister, it was in terms of section 9.1. If you merely read the
You agree.
Paul Park's towel and so forth, by virtue of the powers vested in me in terms of section 9.1.
No, I agree with you. And also, if you look at 9.5, it says the
I
minister.
just wanted to make sure because I thought I missed something somewhere.
I
It
think
is
the-
section 9.
Your leadership is correct. Because even 9.5 says the minister must, before issuing a present code of good practice, publish it for comments, etc., etc.
Thank you.
Yeah. And 12 says the minister must publish in the Gazette for General Information, promote a transformation charter for a particular sector of the economy. This is where it now becomes sectoral.
I beg your
It
pardon.
becomes sectoral. The documents that is envisioned in 12. So a particular sector. If 12 says the minister must publish in the Gazette, what must he publish? For general information and promote a transformation charter.
Yes, it is there in the Act. You're quite correct.
Yes. And then the minister must be satisfied of the following. It has been developed by major stakeholders in that sector and advances the objectives of this Act. We'll argue that the minister has complied with
With section 9.1 or 9.
nine.
Yes.
Yes, exactly. And then if we look further, 13, support services and funding of council. The other sections might not be that important, 13A, etc. Then let's look at what this minister did in implementation of the B-BBEE Act. And I'm going to invite the court to go to the Rule 53
Record.
record. The record has got various pockets. The first one at 614.
Is it 06-14?
6-14.
Only 6-14. No, there's nothing on case lines.
06-14.
Thank you.
06-14 is an index of the record, and it just tells what is it that Mr. Tau had in front of him in order for him to execute his functions. And there is a procedure which is followed in the departments, which is submissions. So, and the minister is asked to do something. The functionaries in the department would prepare a document. There's been suggestions that the minister may not have read some of these things, but he did. He reads.
Although he did not state that, he does read.
Well, if you read something and you agree with it, you don't have to write a thesis. Remember, I've read it, I agreed with it. because that's not how government works. Who do you write to? You write to your officials. They give you a document, submit, say, Minister, this is what we think you should be doing. They take you through it, you look at it, you agree with it, you sign. You don't have to write to them or to court or to record some, in case sometime in the future, there may be a court case in which somebody questions that you read it. You say, well, let me keep this, I read it. That's not how life actually works. We need to be realistic about how things work in practice.
So this is the document that was prepared by the functionaries, given to the minister to consider in before the publishing.
Before the gazetting.
Is this the only document?
No, it's a series of documents that
so this is the first document.
First document. And also, we must bear in mind the timelines. Minister Tau comes into office in 30 June 2024. And at that time, there is litigation. That litigation involves one of the parties in this matter, the Black Conveyancers Association. When you get appointed as a minister, you don't start a department afresh. You take on from your predecessor. And generally, we have a handover. But we don't know. Mr. Tau does not have to tell us in an affidavit and say, look, I met with Minister Patel. He handed it over to me. He told me some of the priorities. One of the things might be the BE codes litigation. And he told me he has looked at it. He doesn't have to say that. It's a meeting between ministers who are, one is taking over. And we must be reasonable to assume that that indeed would have been the case. You don't walk into a department and say, I'm a minister now. It's reasonable. So what then happens is there are various units within the department, SID and ET branch. There are branches that deal with transformation. There are those who deal with sector codes. And they are the experts who've been there for years before Minister Tau came to office. And this is what the submission says. Subject: approval of Gazette for the draft legal BE sector code of practice in terms of section 9.5 of the broad-based economic empowerment amendment 53 of 2003. If leadership is correct, that's how that's how it should read. And it is asked of him to request the minister to consider and approve the proposed deviations of the draft legal sector code from the amended codes of good practice. This would have been done with Minister Patel, it would have been done with Minister Tau. So it is something which happens as a matter of course. But the point is, in his subject, he says, I was briefed. And the submission correctly shows that indeed he was briefed, not only verbally but in writing as well.
What is in paragraph 1.2? The Gazette will provide an opportunity to members of the public to make comments and inputs to the draft sector code. But this wasn't a draft. 1.2, to request the minister to consider, and the next sentence, the Gazette will provide an opportunity to members of the public.
My lady, I may have, I think, I'm probably looking at the one that was sent to Minister Patel. Let's look at the one that was given to Minister Tau.
So this is not the one.
06-14. Give me a few minutes, young lady. I'm told is at 06-258.
06. Oh, thank you. 062587.
2587. Okay. Yeah, that's that's the correct one. Sorry. Thank you. So this is what he's given,
This is 30 August.
30 August 2024. He is been in office from about June,
Yes.
and he's told by a branch, the Transformation and Competition branch, the subject is Gazette of the Legal Sector Code in terms of Section 91 of the Act. This is what he's also told. The former minister gazetted the draft LSC code on 22 July 2022 for a 60 days commentary period by the public. And remember, one of the things that he must satisfy himself, as will come to the statement 3, he must satisfy himself that a proper process has been followed.
Yes.
And this is the checklist that he now gets told. First thing, your predecessor
Has complied with that provision.
complied with that. And he's told 68 written submissions were received from the members of the public. And that is compulsory because you must hear what the sector say. He's then told there's a technical committee comprising of officials from the Legal Sector Code Steering Committee, officials from the Department of Justice and Correctional Services, former, as well as officials from the DTIC, was set up to review, analyze, and consolidate with public comments. A final draft is ready for consideration. This is historical information. He doesn't have to do this thing because these things have already been done. There's a steering committee, it looked at the reports. There was also the Department of Justice and Correctional Services. This is a line ministry. Because the legal lawyers in the country, the regulatory department is the Department of Justice. You've got the LPA, LPC, Legal Practice Council, and then this is where now you see the involvement right at the outset of the departmental officials. And I must say, it is deliberate that the minister comes right at the end to Gazette, because he can't be involved in the discussions, in the reviews and all that. Otherwise, he'll form a view. He won't be independent at the end of the day to say, have you followed the processes? Officials are. And only officials can tell him what has been happening since 2020 when the first code was, the first draft was published.
Mr. Nalani, just remind me, when was the application brought against the minister? That will now be the previous minister, Mr. Patel. Just more or less which year?
Yeah, let me ask for help.
Oh, we can deal with it
You
later.
can deal with, yes, I'm being given the date now.
I'm just trying to work out the chronology.
Yeah. But what we can accept is when he took office, the litigation was ongoing already.
And that was, well, it's not on the paper, so it's not fair to ask you.
Yeah. 13 May 2024, the litigation.
I beg your pardon?
13 May 2024. And the reference is 06-2. But just the date is May 2024.
So it's shortly before the minister took office.
Yes. On 13th of May, Minister Patel was in charge. And that is why he deposited affidavit opposing.
Yes,
Yeah.
yes. I say so it's shortly in May of 2024. The previous minister have these problems, which he states under oath. And then at the end of June,
Minister Tau.
Takes office. So it is more or less a month after these problems, and then he takes office. I just wanted to get a timeline.
Thank you, thank you. If we look, the submission is 30 August 2024. Yes, your ladyship is correct in terms of the timelines. Now, the last bullet point on page 062587 says, it is recommended that the Minister considers and approves the Gazette and Legal Sector Code practice in terms of Section 9.1 of the Act. It is no longer Minister Patel now. Minister Tau must exercise his powers in terms of Section 9.1 of the Act. And then if we turn the page 06-2588, there's a document called Submission Title, Gazette on the Legal Sector Code in terms of Section 9.1 of the Broad-Based Economic Empowerment Act for 2013. And of course, these are government references. They say, number one, submission content, the fact sheet. And then we have two, a presentation. We'll get to that, but what the point is that he was given a fact sheet and a presentation. Because they're asking him, Minister, you must now gazette. A fact sheet, we have told him what the issues are quickly. And if we can turn to page 2573, is a fact sheet.
2573.
06-2589.
89, thank you.
It's a fact sheet, yes. And it gives him just a broad view of what's happening. Interventions in the legal sector code and anticipated key outcomes. The sector aims to achieve a black ownership target of 50% of black women, ownership of 25% over 5 years. And they, without reading all, but they deal with the management control in terms of the code. They deal with skills development. They deal with legal procurement, with procurement. They also give him a feel of the legal sector market size and characteristics. Remember, he's a politician. He was, if I recall, he was an MEC in Gauteng, Economic Affairs. Now he's elevated to the Ministry of. He's not a lawyer. He's not an accountant. He's not a builder. He's not an accountant. He's not a building. Because those sectors have got their own peculiar sector codes. There's a mining charter, there's tourism charter. He's a politician. He's not a subject matter expert. And he need not be. So they tell him, Minister, we are dealing with the legal sector code. Let's give you a brief view what this code, what this sector really is all about. They tell him it contributes 0.51% GDP in RSA. They tell him the proportion and the layout. Ownership by black people is low at 25% on average. This is against the total number of 33,100 attorneys, of which the number of black attorneys is 16,697. They tell him there is inadequate access to a sustainable flow of quality work for black practitioners from the private sector. And then, then they give him, but if we go back to the index of what he's told, he's then given an executive summary and a detailed submission with recommendation/approval signatures. He's given an Annex A, he's given the legal sector code itself. And as we know from practice, if you call somebody to a meeting and you want him to discuss and approve a document, you must give him a bundle first, like in court. I want an order. Say, where are the papers? So that when he meet with the minister, he at least has he has an idea of what. If the suggestion that he only got these documents in the meeting, so he never had time to read them. Well, he didn't sign it. He didn't sign on that day. That's for sure. Madela sees 11 o'clock.
I beg your pardon?
It's 11 o'clock.
We will be sitting until 11:50.
Okay, thank you. Thank you. Yes, God bless.
Time has become very precious.
Time is very precious. Thank you, my lady. Yeah. I think my clock is working otherwise. So he's then given a copy itself, the legal sector code. It's Annex A of the submission, for him to read and certify himself that what they are telling him is true. Annexure B is a submission with the minister's comments. This would have been the previous minister.
I suppose it's here we can have, well, but let's first, let me not interrupt.
Yeah. So, one cannot say that he simply ignored Minister Patel's comments. But in any event, on a broader scale, if you look at the requirements that he has to satisfy, he doesn't have to take Minister Patel's views, he doesn't have to accept them. He cannot, I look
He
at
must
them.
exercise his discretion.
Indeed. It is not a judicial, so he did not take into account the Minister Patel's concerns, therefore, let's review it. That's not, can be. And then they give him an application for approval of LSC. A letter must be written by somebody to say, we have done what we're supposed to do. Let's now have the code signed. They give him a letter of support from the line ministry, and perhaps we should go there. It is 06-2787. I see there's somebody called Korane, Max, who's keeping, oh yeah, people are
Yes,
helping.
thank you too.
They're helping us to direct. This is very helpful.
Very helpful.
I'll just press yes. Okay, it works, yeah. So,
That we can do.
so if we go to 06-2786,
But this is addressed to Mr. Patel.
indeed, but that he has been shown. Remember, he's coming at the tail end. At some point, before Mr. Patel publishes for the gazettes, publishes for comment, he needs a support from the land ministry.
This letter is dated the 7th of June 2021.
Yes.
Would that have been the same? Because if I understand correctly, after the comments were received, the code was then fine-tuned, if one can call that. So is this the final code that was published, that was now here supported?
This is not the final one,
No.
because it must go through various iterations. But before it comes to him, the line minister must write this letter.
But this cannot be the letter. It does not make sense to me. I might be wrong. Chronologically, this was given on the 7th of June 2021.
Yes. It's
But
correct.
leave it.
This is
Maybe it's not taking the matter any further. I just thought
No, but
this
it's
was
important.
the letter of support from,
Justice.
yes,
Yes.
pertaining to the fine-tuned.
It's let me say the following. In broad outline, the sector goes out, prepares its own consultative process with its constituency.
Okay, so in 2021, the line minister, Justice, was already satisfied. He supports.
He supports, yes.
Thank
But what Justice does as of this date, he's giving a narration to the Minister of DTIC
Yes.
to say, I'm supporting this because of what I've seen happening. Would have seen from the first submission letter, the document right at the top, where the executive summary has been told there was a steering committee comprising officials from the DTI and from Justice as well. So the Minister of Justice would have been briefed coming along, and his people would then say to him,
Now, I appreciate that.
Yeah.
I just, the date of the letter was a bit confusing to me, but I hear you. It's not confusing.
so I'll come back in a minute to the statement 003, which lays down the points, guidelines. And somewhere in the submissions, they also tell him, the code says, section 006, if you are developing a sector code, these are the steps that you must follow. And one of the compulsory steps is that the line minister must support. So in other words, the lawyers can't simply go and camp at the Minister of Justice office and say, hey, we have a sector
No,
code.
I totally appreciate and understand that. My only question was the date, but I understand.
And
Follow
this,
you now.
Yeah, this is what he says to Minister Patel, this is Minister Lamola, at 06-2786. Says Mr. E. Patel MP, dear colleague, letter of support in respect of the legal sector code. The legal sector code, the Legal Practice Council initiated a process to facilitate the development and adoption of a B-BBEE legal sector code in terms of Section 9.1 of the Broad-Based Black Economic Empowerment Act 2003 in order to advance the transformation of the legal profession. Until now, legal practitioners who are attorneys are being measured in terms of the generic codes of good practice, generic
Is it
codes.
necessary to read the whole
Okay,
letter
yes.
into the record? I'm just asking, there might be a good reason. I do not want to interrupt.
Okay,
I just think that that letter that was written in 2021,
yeah.
whether what we are concerned, yes, well, it does play a role because Minister Tau had regard there too.
It plays a role because it is part of the legal requirements
Yes.
for producing the
So
code.
that was complied with.
That's complied with. So I'm doing a checklist.
Yes.
Yeah, and
So
what?
we can accept that was complied with.
Yes, but just to read the last paragraph, the concluding paragraph on 06-277. I am now pleased to inform you that the process has been completed, and as a minister responsible to be the policy custodian of the legal profession, I hereby offer my unreserved support for gazetting the legal sector code. I am satisfied that the aligned process has not only undergone vigorous engagement and consultation with majority industry associations, but also has been tested against the alignment principles as required by B-BBEE policy framework and legislation. And this is the Minister of Lawyers says, I'm satisfied.
Well, Minister Patel was clearly not satisfied, but the Minister of Justice was.
Yes. And so this is part of this, the checklist that is given. So he's given the letter from the minister. He's then given Annex E, list of stakeholders. And it is important to bear in mind the word stakeholder, because 12 says major stakeholders in that sector. And that's how I want to emphasize, it is not the minister's code, it is a sector's code. And the Minister of Justice confirms that those processes have happened. And from page 062789, it's Annex E.
I do have it, thank you.
Yes, stakeholder submissions received by the Department of Trade, Industry and Competition.
Well, I'm at least now at number 68, so there were a lot of submissions. I've just been looking quickly while you referred and running down.
Yeah.
There were a lot of submissions.
There are not submissions, indeed, but and that is the point, that Minister Tau can't then ask and say, there was a submission from Legal Aid South Africa. Did you look at it? Are you happy with it? He must accept that those who have got the expertise and the time and knowledge would have gone
I've
through.
just picked up number 54 is Solidarity
Yes.
Law Network. So there was also, well, we know that everyone submitted.
Yeah. But as far as I'm concerned, as far as I know, Solidarity Legal Network are not legal practitioners who are registered with the LPC.
Yes.
They may be trade union members, but that's neither here nor there. But thank you, Manita. That's a very good observation. And to emphasize, This is what Mr. Tau had in front of him. And then if we go back to the table that was of a list of the documents that he had to look at. Annex F, list of stakeholders and participants consulted. But more importantly, Annex G, technical committee appointment letters. It's on 06-2810. I'm looking at my computer to see if somebody's not going to take me that.
Let's see. Should we take the adjournment now?
That indeed, Malet.
The court will adjourn until 11:30. We are all refreshed.
Thank you,
My
Malady.
breath.
I appreciate it. I just want to make one or two correction. I said the generic code that the applicants can comply, can use the generic code. I'm told no, it can't.
Oh.
Generic codes have, so we can only use the LSC. The LSC. But the point remains that you don't have to use it. If you don't like it, you don't have to use it.
Voluntary.
It's voluntary. Yes. And then as far as time is concerned, I have eaten from my colleagues' time. So if I'm a bit slow, it's not because...
No, because your submissions are extremely valuable to this bench. Because you are appearing for the decision maker, aka Mitwa. So, no, it's very important.
Thank you. Thank you, Malady. So if we then go to the next step that was taken, it's Annexure F, not G, Technical Committee Appointment Letters, 06-2810.
280. Thank you.
Yes, and the significance of this.
This is skew on my case.
Yeah, it's the other way around, which is not very friendly reading. But the point is now the DTIC steps in the chain of steps that have been taken. The DTIC, not the minister, but the department itself. They then appoint members of a committee to consider written submissions on the draft legal B-BBEE sector code. And they're appointed by the Acting Deputy Director General, SID and ET branch. The next one is on 06-2811. Is Mr. Thabo Masombuka. And then the important one is on 06-2812. Ms. Christine Kunda.
Yes.
She was in the legal steering committee. The importance, which I'll come to later, is that she is now in the legal sector charter council. And we will deal with the role of the charter council later. They also had Mr. Christopher Loxton, a leading counsel, Joyet Bar, at page 06-2813. Ms. Kathleen Matolo Lepu, one of the other important role players in this matter. She was in the Legal Practice Council, and she was part of the steering committee, and she's now in the legal sector charter council. They also appointed Ms. Melissa Murray, and then Jacob Maputa, who I'm told is dealt with somewhere in the papers, has been involved in very many charter sector codes, about 11 of them, different that has been involved in, which are still in place even now. So the minister is not yet there. These are subject matter experts who must interrogate and look at the comments raised, each one by one. And that's what they then did. At Annexure H1 is what was given to Minister Tau. 06-2822.
Stakeholder submission.
Yes. So they look at the submissions received and they summarize all of this. So that Minister Tau doesn't have to go through it. Can receive a report. What do they say? They look at what each commentator had to say,
All 68 of them.
all 68. Yeah. So that's what they then did. H1, then Annexure H2, 06299. And if I may stay on some of the issues that are raised, for instance, if we go back to 062830, 06-2830, this is a summary of commentary by Allen and Overy, South Africa LLP, one of the major international law firms. What they raise issues with or raise comments on, for instance, on page 062829, they raise issues about clause 18, the ownership scorecard.
Yes.
There's management control scorecard, clause 19. So they deal with all these issues that we are now called, this court is now called on to decide, which were debated and dealt by the steering committee.
May I just ask this? Obviously, the minister must be satisfied that the correct procedure was followed
Indeed.
in collecting the submissions and the whole process that spanned over about 3 years.
Indeed.
But then he's confronted with this document that refers to very complex substantive issues pertaining to what is contained in the legal practice code. What is his role, according to the minister, when he receives that? To what extent must the minister interrogate these submissions? Maybe if you could just elaborate. I'm just trying to understand exactly what the minister's obligation is and what he has actually done, especially regarding the substantive submissions.
Well, one thing that he doesn't have to do is to read every submission. That's he can't have to do. One thing he doesn't have to do is to...
Just a moment. That light, can someone just... It's shining right in my eyes, I don't know. Just turn it... Thank you, thank you. Mr. Nalani,
Yes.
I do apologize.
Yes, thank you. In his affidavit, but perhaps let's look at what the law says he must do. Because it comes at the tail end,
Section 9(1).
section 9.1, and also the guidelines. We go to the guidelines now, which tells what he has to do. Of course, the law is broadly regulatory in nature. It is not specific. It doesn't say to him, you must give us a memorandum summarizing what he did. You must tell us, you have read all these sections. You must tell us that when you read them, how many pages. It's not like me doing an account for the state attorney. They want to know how many pages I've read, when, and what I've done. So he's a minister. So this is what the Section 9 as a leadership says. I think it's more in the code. Let's look at statement 003, which is in the Bible.
003.
Paragraph 3. I think before then, let's start at paragraph 1. One deals with the manner of gazetting transformation charters under Section 12 of the B-BBEE Act. 1.2, the process for developing and gazetting sector codes under Section 9 of the B-BBEE Act. Leadership was correct that there's a distinction between 9 and 12. And 1.3, the status of transformation charters and sector code. And then 1.4, recommend an approach for drawing up transformation charters and sector codes. And 2.1, important, the relevant sector body, together with the relevant line ministry of the sector seeking to gazette transformation under Section 12 must. Now the Minister of Trade Industry come in at 2.1. We have seen Mr. Lamola wrote a letter in support, and now they must apply in writing, which they did, another tick box. 2.12, provide evidence of compliance with Section 12 of the B-BBEE Act as amended. 2.2, the Minister of Trade Industry may refuse an application to gazette the transformation charter if the applicant has failed to comply with Section 12 of the B-BBEE Act as amended. So one of the things that he may refuse, but it means he'll have to satisfy himself that there's been no compliance with Section 12 of the B-BBEE Act. And then 2.3, the Minister of Trade Industry refuses to grant, if he refuses to grant, he must notify the applicant of that decision in writing within 2 months, and the applicant may reapply for the gazetting of the transformation charter by revising its submission. And 2.4, the Minister of Trade Industry must gazette the transformation charter as soon as it is reasonably possible following the granting of an application under Section 2.1.
This is one.
Sorry. I accept that he has to take all of that into account. But if we accept, and we haven't debated yet whether this is a legality review, a partial review, but put that aside. If we accept this is a legality review, then when it comes to the exercise of a public power, a court has a certain approach when it looks at the exercise of such a discretion. Now that's broadly where I'm getting at, is taking or bearing in mind that this probably is a legality review, then certain things are expected of the decision maker. And that is maybe in that context that my question is focused.
So that let me, the case that we uploaded, 19-945. So this, in a way, it informs us what a person in the position of the minister should be doing. I'm reading from paragraph 20 of the judgment, and as I recall, it tells us what a person in in the position of the minister, it's paragraph 20. It deals with the granting. I don't have a power, but discretionary power. Because as we see, his power is discretionary. He may refuse, he may grant. So it is, he must accept that power. The court says it's Minister of Environmental Affairs and Tourism versus Cinematic 14, 1995, 6 SA 182. In paragraph 20, a functionary in whom a discretionary power is vested must himself exercise that power in the absence of the right to delegate. In Hofmeyr versus Minister of Justice and another 1923 SA 1086 at 117 FG, King J formulated the rule as thus. It is well established that a discretionary power vested in one official must be exercised by that official or his lawful delegate, and that although where appropriate he may consult others and obtain their advice, he must exercise his own discretion and not abdicate in favor of someone else. He must not, in the ways of Baxter administrative law, pass the buck or act under the dictation of another, and if he does, the decision which flows therefrom is unlawful in nullity. As to the reliance on the advice of another, the functionary would at the least have be aware of the grounds on which that advice was given. But it does not follow that a functionary such as the DDG in the present case would have to read every word of every application and may not rely on the assistance of others. Indeed, given the circumstances, Parliament could hardly have intended otherwise. What this other functionary may not do could hardly, what the functionary may not do, of course, is adopt the role of a rubber stamp and so rely on the advice of others, that it cannot be said that it was he who exercised the power. If in making a decision he was simply to rely on the advice of another, without knowing the grounds on which that advice was given, the decision would clearly not be his. But by the same token, merely because he was not acquainted with every fact on which the advice was based, would not mean that he would have failed properly to exercise his discretion. This would be particularly so if that advice was merely one of the factors on which he relied to arrive in his ultimate decision. So he has a string of advisors in the department. There's also a steering committee. A technical committee has been appointed by the very same department. He cannot simply say, I don't like what you're telling me. I think go back to the drawing board, given what is given before you. And if I may make that point further, there is a document in the, if we go back to the record, there's a presentation that was given to him. So he wasn't given textbooks to go and read and answer questions. He was also given a presentation which summarized for him what, because sometimes it's very difficult to just read, but when you are advised in writing, verbally, and you are able to ask questions, it helps as well. So the point of the matter is that, yes, he ultimately has the power, but he can rely on the advice given. And once I find the reference, I'll go to the presentation, which shows that he had information in front of him to make the decision whether or not to gazette. He didn't need 6 months or a year. That was done for him by his predecessors. And the sector.
Obviously, you heard the applicant's criticism, especially directed at the answering affidavit of the minister. If I can briefly summarize, it seems to say that the minister just rubber stamped the legal sector code as was presented to him. May I just ask you to just give me a brief summary of the minister's response to this criticism? Does it have any merit, or should we reject that?
It must be rejected offhand. We live in a real world. A politician who has a Department of Trade, Industry and Competition is not a DG. He's not a DDG. He's a minister. He's in charge overall. That's how life works. You walk into a department, you say, there's this issue about BEE. is part of the strategy of the government, and this department in particular, to articulate and formulate and make sure that that happens. You say, what happened? They give a briefing, they give notes, they give a presentation. You say, I agree. He did what any sensible official would do in any circumstances. Thus, criticism is not justified at all. The suggestion is that he just came, was shown a piece of paper, and he signed without reading it. He had meetings, and he was told what happened. And he reads. I mean, to suggest that he doesn't read without, now the onus is sheet on him. Minister, we think you didn't read. Show us that you have read. It's the other way around. It's like asking a judge to recuse himself.
That's a good example.
Very relevant.
A judge takes an oath of office. They take an oath to uphold the law, and so you must assume, until others proven, that they are acting otherwise. A minister of government, as learned as Mr. Tau, can be assumed to know what he's doing. He gives briefings, he must give interviews, he must appear on TV, on radio, and explain to the people of the country what is the strategy of government on BE. Then he said, no, he didn't read the legal sector code at all. It defies logic. There's a presentation which was also given to him. It's on page 2591. Yes. These things work well. 06-2591. Presentation at the Ministry of Trade, Industry and Competition. Legal Sector Code. 20 August 2024. At page 06-2592, there's a presentation outline which is given to you. Background, legal provisions of the sector codes, the purpose, objective, challenges in the legal profession, evidence to justify the development of the legal sector, specific provisions of the legal sector code, elements of the legal sector code targets, key comments against the legal sector code. He's told there were certain concerns and comments against him. He is in this meeting. And he says, I was briefed. Now, what he says under oath, I'm briefed. You can't doubt his word. And then the last bullet point that says, ground supporting the Gazette in the legal sector code. So he's given this roadmap. We'll tell you the background, we'll take you through the problem. Then at the end of the day, we are going to ask you to sign. And sign or refuse, yes. And he didn't sign on the same day. He signed, we know he signed in September. So he must be taken to have a time to breathe and consider what was given, at the very least. At page 06-2592, the background is given in a schematic fashion. He's told the background 2021, 2022, 2023, and 2024. Those are the summaries. And then at 06-2004, he is given the legal provisions of the set. They are explained so that he can understand as well. And yes. If I may go back to 2592, there is that box which says 2024. It says submission for the Gazette or the LSC under consideration. Issues raised by Minister Patel, evidence-based justification for deviations and action outside the past and Minister's mandate. Amended LSC and evidence based on sectoral characteristics and empirical research submitted to justify deviation. So he's told, with the general code, you can deviate. And I think my other friends admit that mere deviation from general codes is not unlawful. In fact, it is embedded. It says you must deviate.
Yes, on that, there are three riders to that. Yes. If one deviates, it must be for one of those three reasons.
So we'll get to the deviation memorandum, which also served before Minister Patel, because the steering committee prepared a detailed memorandum. But this is what was discussed with him. The presentation says, at least he was presented on the issues raised by Mr. Patel and the deviations. And they go on challenging the legal profession, 062596. Evidence to justify the development of legal sector code at 06-2597. They take him through the whole program and diary. 2014, they tell him about the research by the Center for Applied Legal Studies and Foundation of Human Rights. 2014 shows corporate law firms surveyed are dominated by white males. Now, one of the criticisms was that the data is too old, 2014. This court can't help us on that. Can't help this resolving this issue. The point is, they had data. You can criticize this, and I think some of the stakeholders and commentators said, yeah, it's too old, but some things don't move as quickly as one would like it to. And the fact of the matter is, as we stand now, you can go back to 30 years ago, there's been some movement and change. If you subject that to statistical analysis, things don't change in a day, maybe a decade or so. Things tend to move. So the criticism that is laid is too old is not justified. And this court can decide that issue. They then go on to talk about the provision of the legal sector code. At the very least, if Minister Tao can read, he must be given, he can listen, can hear. He was given a presentation. That must at least be given to him. And they then deal with the elements in the legal sector code, ownership. They say to him, the overall target of for black ownership is 50%, and black women ownership 25% over a period of 5 years, which are higher than the 50% black ownership and percentage black women ownership in the general codes. And he's told all this. So when he says, I agree with the code, it is sheet from the general codes, he has at least listened. You've not read. And they deal with all these issues. Skill development on page 06-2602, enterprise development, and they deal with the transformation fund at 06-2603. We would recall the reference in the strategy document, which might be not in line with section 11. There is reference to funding of empowerment companies and institutions. And here is a transformation fund, which is proposed to be established to be utilized for skills development. And then they deal with the legal sector code scorecards, 06-2604. And most importantly, they look, if you look at on the left-hand side, ownership, fundamental control, skill development, they give the weightings in line with what Statement 003 and Section 9 would say you must do. You must give weightings. And then there's a scorecard for advocates, 06/2606, which you must comply. And there are compliance targets which are set out from 06-2608. If we look at the first column, monetary threshold for LSMEs generating more than 25 million per annum, ownership, voting rights, and there is a progression of how long you should need to achieve those targets. Year 1, 30%, year 3, 40%, year 5, 50%. And all these elements are addressed comprehensively in the submission to him. And he's there listening. And then if you look at 06-2619, issues raised against the legal sector code during public comment period. He's told Minister, this has not been smooth sailing. There are those who do not, have got issues about the sector code. And they addressed to him the legality at 06-2620. They tell the minister there has been issues about constitutionality. Some people have said this code might not be constitutional. They say, in response, it is admitted that none of the provisions of the LSC are contrary to the Constitution. The LSC is designed to ensure that the constitutional right to equality is given effect. Thus, the issue of constitutionality is invalid. Legal opinions were presented by the DOJ in support of the constitutionality of the LSC prior to the Gazette of Public Comments, and they affirmed that the LSC is not unconstitutional. So he's told the law is on your side, Minister. There are issues about right to fair trade, they deal with that. And one of the things as well, which is a point here, it's about the codes. The point that was raised was development of the LSC does not comply with the requirements of the B-BBEE Act and the codes. And they deal with this issue. In response, it is admitted that all the requirements and processes were fully complied with, and there is evidence of extensive consultations where all stakeholders were involved and also given an opportunity to submit inputs. The LSC is supported by the Minister of DOJ. It was also approved by Cabinet. He doesn't have to ask for information, this evidence. He's told, and he must accept it. And let me just pause here before I forget. There is a criticism about the affidavit of the minister where he said, almost suggests that he has no option but to gazette. And that was taken as almost putting his arm in the air and saying, I have no option. I'll find the reference now. But what he says is part of responding to the case. He explains in a number of paragraphs. He says, so my learned friends only quoted one paragraph where he said, I'm duty bound. But elsewhere he says, I have no reason to refuse. So one can't read one sentence in isolation. He appreciates and agrees that he can refuse. I said, in this case, I cannot refuse because there's no reason. He would in fact be acting irrationally if he says, I know you have done the steps that the code say you must do. Statement 3003 says do steps 1 up to 7 or whatever. You have shown me the evidence that you have done the steps, but I'm not gazetting.
I am not?
I'm not gazetting. They'll take him to court. And the court will order, but Minister, this is not your code. It is a legal sector's code. But back to this presentation. Then they tell him at 06-26222, grounds for supporting the Gazette of the LSC. Bullet point 1, all requirements have been adhered to and there is sufficient motivation in support of the Gazette of the LSC. And they give him all the reasons. Then conclusion on 06-2623. Once gazetted, the sector will serve as transformation guidelines for the legal profession and all measured entities. Providing legal services and procuring legal services will be required to comply with the legal sector code. The issue continues to be highly contested as black law firms and practitioners are pushing for transformation in the legal profession. There is pushback by established white law firms and practitioners who are not in support of the legal sector code, as evidenced in the public comments. There is a high possibility that the contestation will eventually be expressed through litigation. And lo and behold, here we are. Black legal practitioners have already instituted legal action in seeking the approval and publication of the LSC. And then they give him an executive summary again at 06-625. They summarize the issues and they ask him to please sign, which we know he ultimately did. Now, what has he done wrong to invite the opprobrium on the court to say, let's set aside this code because it is irrational The targets that are being put are impossible to reach. You can't make partner in a big law firm within 5 years. It might be 6 years or less. Those are not the debates which this court can resolve. The lawyers must resolve them themselves. The code established an institution called the Legal Sector Charter Council. It says that Charter Council will be responsible for the monitoring, compliance, and, if necessary, revision of the codes. It is established and known that nothing remains static.
Do they have the statutory power, or where does their power emanate from to amend the what the minister has gazetted?
Let me read to the court the responsibility for monitoring the implementation of the LSC. It's an extract from the Legal Sector Charter Code. LSC, paragraph 13, responsibility for monitoring the implementation of the LSC. Am I directed? Okay. No, it's not right. Let's try this. Yes, the Charter Council itself. The code. Let me read in the meantime. 02. It's yes, 02-1382.
02-1382. And we are looking at
paragraph 13.
Yes, but what is this document?
It's an extra. It's part of the legal sector code itself. It's part of the code.
Thank you.
Yes. It says responsibility for monitoring the implementation of the LSC. 13.1. Subsequent to the Minister gazetting the LSC, a charter council shall be established comprising of stakeholders in the legal sector in accordance with the provisions of the B-BBEE Act as read with the provisions of paragraph 6 of Statement 003. The Minister of Justice is responsible for the establishment of the Charter Council. Stakeholders, 13.3, stakeholders in the legal sector shall nominate members of the Charter Council.
Now, I accept that. Yeah. I just wanted to know, does this code confer power, the power that a minister has in terms of Section 9.1 to publish and gazette? May this commission or charter council then do their own thing and change what the minister has gazetted?
No, the ultimate power lies with the minister, but they are the liaison, the mechanism which operates on a day-to-day basis. If there's a need to revise, they must consult with the yes, I'm told 13.74.
13.74. Initiate and supervise revisions to the LSC.
Yes. So it plays a role, because the minister can't simply say, I'm changing the code now.
No, I accept that. I just thought that maybe I've heard incorrectly, that the submission was that there is this charter council who can change if there's something wrong. I might have heard you incorrectly. Yeah. They do not have the power to do that.
No, you don't have the power to do that. You have to go through iterations again, public comments, and then the minister will be asked again to amend. And he is the one who exercises
Thank you.
So without, now, we know that in August 2024, the minister is given the presentation, is given all these bundles, papers, annexes. I think we must at least give it to him that he read the papers. Yeah. Because then in September, he gazettes. And where did he not apply his mind as the main question? And that is one of the criticisms against the minister. Well, if he had applied his mind, he wouldn't have allowed for the scrapping of bursaries for black students. Well, if he had applied his mind, he would not have fixed the period for reaching the targets at 5 years, it would have been more. No, he shouldn't have allowed the exclusion of management of law firms who are not lawyers. He should not confine it to lawyers only, but that's by the by. It is a code which somebody might want to have, but it is not a code that we have now. And this court cannot go into the substance of the debates and second guess the whole sector, including the minister, and say, no, we as a court think you should reinstate the bursaries. We as the court think you must include the ordinary persons who are employed in a law firm for purposes of the scoring. You can't say, well, you must now include a new socio-economic element that if I spend money funding the lady who delivers flowers to the firm, I must get points for that. It's a different ball game altogether. If you don't like it, don't comply. You don't have to. And so I want to note here, the Charter Council has been given the role to monitor, initiate, revisit, amendment of the LSC. Because we all know things change. And some of the requirements for compliance.
We accept that. We accept that the legal or the Charter Council do have these functions, and as we've discussed that, but they do not have the authority or the power to change on their own. They must go back to the minister. But they have all of these powers. They must revisit. They must, because as you say, times change.
Times change.
The thing is.
And I'm going to deal with another point once we've done with the major points. It's about joinder. We have pleaded that the legal sector council, Charter Council, should have been joined as a party. And the answer we get is no. We are challenging the law that created the charter. We're not challenging the Charter Council per se, and that we are not challenging. We are. If we challenge successfully the code, the Legal Charter Council will fall by the wayside.
Yes.
In any event. But that is not how I understand the issue of joinder. The issue is, will the order affect you? Not the way the claim is framed. It may be framed this way or the other way. That's not how you determine the joinder. The order of the court that is granted, do you have an interest in it? Will it affect prejudicial interest? And the Charter Council, yes, it will affect them in this way. There are some law firms, I dare say the majority, because the applicants here are about 4 or 5 law firms. There are other law firms which are big in size as well, which deal with the same issues that big law firms deal with. I mean, it's a bit of a unique sector within the legal sector. But they are not challenging the code.
Well, if I understand it correctly, and you must correct me if I'm wrong, that 95% of the legal sector does not need to comply with this code. It's not applicable to them.
No, they have to comply, but the manner of compliance is different. In certain cases, you just have to sign an affidavit to say, I earn this much, and therefore you'll be given appropriate level of. If you are bigger, you have to meet all the elements. You must demonstrate that, in fact, you deserve to be given the rating that you are asking for. So that's why there are scales depending on turnover. So some are complying now, and they are looking for, there are certificates of rating and the stamp from Charter Council that you are this level or that level or the other level. So they have an interest in maintaining those ratings because they're important for them as well. Part of the rating regime is to enable people to gain benefits of being rated. Make the cycle bigger. That's it. So now, the law firms which are complaining now, they want to hold on to the generic code because it gives them bigger rating. And then, of course, it does, but that's generic codes. Now there's a new code in town, the LSC. And some of the complaints is, we don't want to comply with it now because we are fine. We have generic codes, ratings, and certificates, which we promise our clients that will maintain those so that they can continue giving us work. And so we don't want to comply with LSC codes because we will drop. But those are commercial private interests between the applicants and their clients. They have nothing to do with 95% of the sector. And the minister, part of his functions is to regulate competition. The advantage of those who comply with the LSC is that they can gain access to work which they would never gain before. So they too have an interest in maintaining the code. And one must look at it in broad outline. The Charter Council is there to make sure that this regime of empowering people, giving them certificates so that they can go and ask for work from the government, is maintained, promoted, and encouraged. Their function is to implement the legal. If the legal sector code goes, it means they are gone. They're gone now. It doesn't matter why you think they must be gone, but the fact is they'll be affected by the outcome of the order.
Well, they're a creature of the code.
Yes.
The code is being is the subject matter of this review. So if the code goes, it follows naturally that they go. But I hear you. So you're still raising the non-joinder.
We still raise the non-joinder.
So do you want us then to dismiss the application on your non-joinder?
Indeed.
Okay.
Yeah, that's the point. And we're making practical illustrations to show that they have an interest in the matter. If they are joined, they can be able to add value to this court. One of the things I will tell the court, because the court must give a remedy at some point. Even if the court thinks the code must go, it must at least say what are the benefits, the competing interests. The Charter Council Legislation, the majority, or they can give statistics, are complying. Now, if you set aside the code, it means in the interim, they're going to lose their rating. And the current law firms...
If the code is set aside, wouldn't the default position be that the generic code then apply? It must be so.
I'm not very certain that it must necessarily be so, because the generic codes, they are no longer applicable to this sector. You can't simply default to the...
Well, if we set a code aside, then there's no legal code, but yes.
Yeah. But
maybe
I'm just saying, legal interest in the outcome of the matter is much broader than simply saying, we are challenging the law that created you. Therefore, you have nothing further to say.
Yes.
Yeah. I want to close off the point that and in his affidavit, just to close off the point that he didn't apply his mind, the minister. The record shows otherwise. There are many submissions which were made until he signed.
And it's detailed submission.
It's detailed submissions. So when he says at page 02, at 02-1215, paragraph 55, Mr. Jacob Maputa signed a new submission on 23 August 2024, which was supported by Ms. Susan Mangole on 26 August 2024, and Mr. Malebo Mabiche Thompson, Acting Director General, on 30 August 2024. 56. This memoranda contained the advice which I acted in gazetting the final LSC. It helped me to apply my mind to the issue of the finalization and gazetting of the LSC. 57. I was briefed about the process undertaken for developing the LSC by the legal profession. The profession first adopted the legal sector charter as a transformation charter in terms of section 12 of the B-BBEE Act. This was done in 2007. Excuse me.
Let me join you.
And then, just to close off the Minister Patel issue, at 02-1213, paragraph 48, the submission advised me on the history of the drafting of the LSC, as well as the concerns raised by Mr. Patel, and that these have now been addressed. 49, I'm satisfied that all objection comments about the LSC, which may have stood in the way of the gazetting and pardon provisions issuing were fully addressed. My colleagues will elaborate a little bit more on the legalities of the standards of review and all of those legalities. But the point of the matter is the following. When the facts show that the minister has followed the letter to the T, the grounds of challenging him must surely be very narrow. As we understand it, one of the issues is rationality, based on the principle of legality. My learned friends will elaborate further, but the point of the matter is that is a very low bar to jump. You just have to show a connection between the means and the end. It's a rational connection. The code is meant to promote transformation in terms of the Constitution and the law. They say so, the legal code says so in so many terms. It also demonstrates that that is the stated objective. It is rational. And if I may just turn back to my heads of argument, just to illustrate where we deal with some of these points. From page 19-198, we deal with the background, which we've covered mainly through analysis of the memoranda, which contain the history of the matter. We go on to deal with the various iterations of the code and the transformation fund, the thresholds, and then at paragraph 74, page 25, we deal with the issue of non-joinder, which I've just articulated. I'll not repeat it, but that's the point we make. And then at paragraph 80, we deal with the second point, eliminate solidarity. Which lacks-
80.
80.
Oh, yes, yes. Solidarity lacks locus standi.
Yes. And I think the point, the simple point is solidarity is a trade union. And the leadership asked very pertinent questions yesterday. Are there lawyers who are members of the union who need representation? As we all know, one of the lowest life of existence in the life of a lawyer is being a candidate attorney. But even they don't need a trade union. They have a contract signed with the LPC. Trade unions within a legal firm setting would represent the employees, not the lawyers. Like your ladyship, never had, first time I hear, never heard of lawyers being members of the trade union. You ask solidarity to fight your battles with your partners. So it's a non-point. Paragraph 81, it say Section 200 of the Labor Relations Act 66 of 1995, which is where their regulatory powers lie. They are regulated by the Labor Relations Act, not the Legal Practice Council. And it says a trade union may act in one or more of the following capacities in any dispute in which any of its members is a party. That's where it ends. Their members are not a member. Their members are not party to any dispute. 811 in their own interest. 81.2 on behalf of any of his members, and in the interest of any of his members. What they should have done is to give us a list of their members, and then we would have seen that they might qualify on some ground or another. Of course, many NGOs, in the pursuit of their objectives, would need to represent other people who may not be able to have the means and wherewithal.
The fact that the submissions by Solidarity were accepted and dealt with, that in itself does not give Solidarity locus standi.
No. As you know,
Because the public could make submissions.
Exactly. As we all know, you must write exams first to be a lawyer. You don't just become a lawyer. It takes a lot of effort. No, it doesn't elevate their rights. Doesn't give them any rights.
I think because the public may also, anyone in the public, if I understand it correctly,
Indeed.
could make submissions. It was not only lawyers. I don't know, I'm asking.
No, your lordship is absolutely correct. There is a term which Justice Madlanga uses in one of the judgments. I think it was Helen Suzman Foundation versus the JSC. It was about deliberations during appointment of judges.
Yes.
Yeah. And he says it's about access to information. He says, there are these people, he calls them busybodies. They just ask questions, and if there's a tender, they apply. So if anything, they challenge it. A busybody doesn't make you a lawyer. I can comment about the regulation regulating orthodontists.
I just want to make sure we don't have to decide that.
So, and then we deal with public interest. So you can't just say because it's public interest, I say I'm public interest, that qualifies you to act for people. There are various factors which you must be able to take into account. Section 38 tells you what you must show to be acting in the public interest. And they've not met those requirements, we say. And then we, at paragraph 96, page 19-221, we quote the case for Police and Prisons Civil Rights Union and others versus National Commissioner of the South African Police Service and others. It said, and I quote, in deciding the question of local standing of the applicant in bringing up action on behalf of the group, I am of the view that the court must look at the individual circumstances of the case, the wrong that is sought to be kept, the group of persons in whose interest the applicant claims to be acting for, the location and expanse thereof where the group is to be found. The list is not exhaustive, but this circumstance would be determined by the dictate of the particular case. Without attempting to answer the questions referred to in the Independent Electoral Commission versus Langeberg, I am of the view that the interest and the connection will depend upon the circumstances of a particular case. However, the importance of the interest to the applicant and his members, the seriousness or gravity of the encroachment to such right, and the remedy sought are some of the factors that will guide the determination of the interest in connection. The geographical spread of the members of the applicant in Kasu is also a factor to be considered. So in conclusion, we say no, there's no entitlement to be here. And like Justice Person asks, why are you here? Question to the. So why are you here? That's the question. I'm not sure that question has been adequately answered even now. And then in page 89, I think we just deal with the part of the minister which we've dealt with in the Act about where it places him in the order of things. Section 10, Section 9. I'm flying through. The other point is the issue of the guidelines.
So the statement.
Yes, the 003 statement. What we are told is that one of the grounds is that the code breached
the guidelines.
The guidelines. And we say at paragraph 113, and just at as we understood the submission, the applicants contend that and argue that the minister of the DITIC did not comply with the guidelines, or if you comply with the guidelines, then this decision axiomatically unlawful. We say the guidelines are not binding or legislative. They are a guide for the decision maker. The decision maker may use their discretion and decide whether to apply the guidelines or not.
The minister's position is that he did comply with the guidelines.
Indeed. Yeah. And so to the extent that there might be said, you did not comply.
Certain instances.
In some instances. But it certainly doesn't kill the whole code, which would be matters which come to remedy. And my learned friend for the Minister of Justice will address the point of remedy. Because just because black law students no longer have bursaries doesn't mean you must strike down the whole code. Can't be that. Just because the
Can it be unscrambled? Can one unscramble the egg?
Well, yeah, even that is not very difficult. So, well, I'm ordering you now, you must give them bursaries. And it goes to this whole legality, rationality. We quote from a case of MEC, Western Cape Department of Social Development, versus BE on behalf of JE and another, where it stated as follows, at paragraph 114, page 19235. As guidelines, this had no binding legal effect, but they provided an indication of what was expected of those responsible for the regulatory oversight of places of care and similar institutions.
Is there a difference if there are peremptory language in a guideline, does it change the binding, how binding that guideline is?
No, it doesn't change the nature of the guidelines. They remain guidelines.
And
and
insofar as they are peremptory, it doesn't matter.
if you apply them, if you choose, I'm going to apply them, and they say to you, you must do this and that, I'm not sure if you don't do it, because
Because
sometimes
it is the minister himself who gazetted those guidelines.
yes. But sometimes, as lawyers, we make the mistake of simply saying because it's peremptory, therefore, if you don't comply with it, there are consequences. It depends where it is placed in the scheme of the instrument itself. Let's take, for instance, the strategy document. You can't axiomatically say, because there's no strategy, therefore, you're acting unlawful. It depends on the purpose of that strategy. What does it do in the bigger scheme of things in you developing the codes?
Yes.
What is the purpose? Sometimes the law will say, if you don't do X, you must be fined. It doesn't mean that what you do legally becomes, in a civil litigation, that you can set aside that action. You must look at it in context, in context. So the broad argument that there was compliance or non-compliance, therefore strike out, it doesn't apply. You must locate within materiality of the decision-making process. And on that point of the peremptory nature, paragraph 120, in the case of
Airports
airports,
company.
page 19.
I'm reading, is it the airports company matter?
Indeed.
Yes.
So it says the peremptory nature of the provision of B Act, and this deals with the Act, not the code. Yeah. It's already been stressed in the preceding paragraphs. It is clear that deviation of the B codes is permissible only in the circumstances alluded to earlier in the judgment. While it is rational to set the B-BBEE's criteria for purposes of promoting transformation, the choice of the specific criteria must be informed by reason. The minister has told you the sector itself. They have said that it is because of the unique circumstances of the sector that some things can't be followed slavishly in the general code. You have a profession where there's no division necessarily in many cases between management and shareholders. In a law firm, the shareholders are the lawyers and they are the management. And so you can't apply management principles which you apply to a company, a commercial trading business. And
But it does not need to be lawyers. I mean, it's a company.
yes.
So if someone who's not a lawyer wants to be a shareholder,
Yeah, but you can't be a shareholder in a law firm, as far as I know. If you're not a lawyer. That's,
director?
director is something else. Yeah, because some firms are incorporated. They've got directors. Some are not incorporated. But I can't buy. I wish I could buy shares in one of these, but I can't. Well, maybe I could, but I might have to leave an advocate. You know, there are all these regulatory
I
issues.
hear you.
So the point is, you can't simply say the general code say this. Therefore, if you depart, you are out. And then we make the point at 121. The memorandum of deviations contains all the deviations and their justifications. We deal with these issues in the heads. I will not repeat some of this. And then at 136 we deal with the page 19-243, we deal with the rationality issue, where we say, in reference to the above case, the decision to gazette the LSC was rational because there is a connection between the decision taken to gazette the LSC and the purpose for which the decision was taken. And we refer to the case of University of the Free State versus AfriForum and another. The citation appears there at the footnote. I accept, however, that the decision to adopt a new policy may be subject to legality review on the ground that it was made in the exercise of a public power. The question to be considered in this context is whether, objectively viewed, the decision was rationally connected to the purpose for which the power was given. This is a factual inquiry, and courts must be careful not to interfere with the exercise of power simply because they disagree with the decision to consider that the lower power was exercised inappropriately. If, therefore, the decision maker acts within his powers and considers the relevant material in arriving at a decision so that there is a rational link between the power given, the material before it, and the end sought to be achieved, this would meet the rationality threshold. The way to be given to the material lies in the discretion of the decision maker. So too does the determination of the appropriate means to be employed towards this end. But if a decision maker misconstrues his power, this will offend the principle of legality and render the decision reviewable. We have demonstrated through the facts that the minister acted within his powers. He took into account the relevant considerations. The end justifies the means. There's a connection between the power, the material, and the objective sought to be achieved. And then paragraph 19234, 142, we have dealt with the issue of Minister Patel. We don't need to repeat it. Paragraph 144, we have dealt with the constitutionality of the code. It is in line with the act. And at paragraph 151, we state at page 19-247, the applicants allege that the LSC fails to be reviewed and be set aside on the basis that it constitutes an unconstitutional measure under Section 9 of the Constitution, and that the decision maker failed to explain the basis on which the measure is formulated, to base the measure upon proper information, and to conduct a proper assessment. We disagree with the argument. LSC has an objective on improvement of the levels of transformation already achieved by the B-BBEE Act. However, transformation in the legal sector achieved by General Code really result in benefits for historically generated persons, which we say it doesn't go far enough. And then we deal with at 19-248 the targets and weightings of the targets. We submit that the targets and weightings in the LSC are rational, reasonable, and justified. If the court would find that they are unreasonable and overreached, we submit that would not be a ground for review, but the LSC may rather be amended than set aside. That goes to remedy. I had one of my learned friends submitting that if one element of the LSC is found to be reviewable, then the whole house must fall. It would not make sense. And I hear the issue was how you reallocate the points, that the whole scoring mechanism falls, but that can't be. Let's say, for instance, the court says you should have included the socio-economic element as one of the scorecard elements. It doesn't affect ownership, doesn't affect management, doesn't affect other elements. You're simply saying include it. And then you may reallocate the points, but it will not disturb the entirety of the character of the LSC. And it would not need, for instance, that because you did not did deal with them.
But the
burdens-
points will need to be reallocated.
But that is not impossible to do. You don't have to scrap the whole thing.
No, I hear you.
Indeed. That's the point we're making. And then the other point is that there's no transitional period. Well, that's what the guidelines say. You don't have, if you want a transitional period, then you must amend the code, the statement 003. That's what it says. The Act says that. The guidelines.
So is statement 003, it is applicable and binding,
Yes.
only applicable.
Indeed. But you can't then say, let's set these codes aside, the LSC, because it provides no transitional period. The guideline says no transitional period shall be provided for in the implementation of a sector code. That's
But
paragraph
we've
3.
already discussed that the minister is not bound by those guidelines. The minister could have set a longer transitional period.
Yeah. I agree. And then to go back to, I don't spend too much time here, the solidarity arguments that the sector code contravene the Employment Equity Act and the ILO Convention 111.
I don't need
If I had
to,
correctly, they are
need to
leaving
spend much
the
time.
international obligations. The Employment Equity Act, we see this in paragraph 162, page 19249. It states the purpose of this act is to achieve equity in the workplace by promoting equal opportunity and fair treatment in employment through the elimination of unfair discrimination and implementing affirmative action measures to redress the disadvantages in employment experienced by designated groups in order to ensure their equitable representation in all occupational categories to the levels in the works. That's not what the LSC does. It's not about employment equity. And we restate the purpose of the LSC in paragraph 163. It's about practitioners, legal practitioners, not employees generally.
Transformation.
So that deals with the solidarity issues. They said Public Finance Management Act. That I don't see how that really comes into the picture. The PFMA, which is meant to regulate the spending of money by departments, not the empowerment of black legal practitioners. So that argument cannot stand.
It's got another purpose
It's got
altogether.
another purpose altogether. I'm almost running out of words. I see my head say conclusion.
I also saw that.
But before I conclude, I thought I'd just take a few minutes to,
Yes.
especially my other colleagues who are also. What time is it? Yeah, could we possibly adjourn early for lunch?
Yes, 10 to 1, and then we'll reconvene at 2 o'clock.
Thank you.
Court will adjourn until 2 o'clock.
Remember when they said stick to our argument, stick to the submission.
That was it. go through the record in some detail to illustrate where the minister confined and date the role as constitutionally and legislatively required. May I also make this remark that this is not the minister's code. It is a legal sector code. And I think once we characterize that, it shapes our philosophical approach to the role and functions of the various role players who are key to this process. I characterize the minister's role as that of a midwife of some historical facts that I read and came across in my youth as I was growing up. Studying the South African history, we all know there was something called the Anglo-Boer War. History has corrected us in this nation. We know that the National Party was a party primarily to take care of the poor white collar. Won the election in 1948, and they build institutions which would benefit, uplift the people after, create banks, and a big law firms. We had work from the big banks, strong class banks, to pay to solve the poor white collar. We can tell you about what the squashed ethics. Here we are today, black legal practitioners. They too have been the victims of squashed earth policies. It is a matter of historical matter which we think the minister should have had in mind in this way and that way. Would we say he should have not gotten rid of black or buzzed of black students? And that's the agreement. And the architecture of the imposition and development of charter is that everybody is taken care of. Everybody's views count under the sun. Everybody is received. The applicants participated, which are shown in the record, in the entire process of forming the legal practice code. They made comments. They had certain, as they should, concerns about certain structures of the code, which they articulate in the various stakeholder meetings, even with the ministers. Today, yesterday, they are rehashing arguments. They are rehashing issues which they had an opportunity, which the law, the architecture of the system allows for them to answer. They are not asking here to decide who is right, who is wrong. Not only that, the structure of the code has created a new structure altogether, which is a mini-regulatory institution on the code. I must confess, reading through the code is a very elaborate process. It's not an easy thing. It's targets. So we have a specialist body which functions this to make sure that all of us, practitioners to the system, will help us to interpret it. Not only the executive, make sure functions.
Should the court have regard to the law whether this code was preceded, was prevented, or rather was established by the minister within the constraints of the legislation?
We will do that the first part of our video. We will look at the legislation and how it dovetails with the various code of practices and guidelines which are meant to be applied. But the point I'm making is that the applicants don't have to apply the code. They can stick to the generic codes, which the leadership is. There's nothing to gainsay what they're doing. They are complying with the generic code. And nothing, the generic code has not been abolished. It's still there. If you want to comply, you can comply and go to the plans that I comply with the generic code. And you can get your work on the basis of the relationship which we have with your client and the commercial agreement which we have. And now to come and say this is unlawful. You don't want it. It is irrational. It's unreasonable. It sets impossible goals. It doesn't achieve what is meant to do. go back to basics about the legal structure as well as how this was brought up. Of course, this is about lawfulness. Did the minister act lawfully? No. Of course it did. There's a duty, section 9 of the Constitution says it is imperative. Equality is an imperative in this country. Not only in form but in substance. It is not only form that you are all, of course, in principle, all equal to the law. But we know that in real substance, we know. And you know that even gender is a big issue that plays a dividing role in our country. Section 9 and other provisions of the Constitution says you must put in place measures which recognize one, that some people in this country is turn against husbands. Let's put in general women. If human beings are as good as we think they are, we would not need laws. They would do the right thing, they would empower others, but we know that's not how it works. That's what the courts work.
So I am just trying to understand, because before it was raised yesterday, it was not a point that we will. I personally I'm trying to figure out where it fits in. So it is the minister's prerogative to ask advice from this council. It is not a must.
And also the reference to trade unions in business committee at 2B is to have as wide a representation of the cross-sectional committee as possible. But this is not a sector code. Sector code is specific to a sector. So another one so that they are confusing this and the other sector-specific institutions. So this is because they are a trade union. They want to jump into this court. As you asked yesterday, why are you here? And so they have to try and claw back. One of the things that they just see the word trade union and then voila, we're in. But it's not, it doesn't work like that. Because this deals with policy generally. And then we'll then, as we go along, see.
Does that fit in with the generic code, for instance? Because the generic code is not sector specific. So would that be an instance where this advisory council, well, maybe I'm speculating.
They can give advice, saying, we need generic codes, for instance, and this is our views, and that's how far they get. The mechanics of creating those things is not within the council, the minister's prerogative and function. And if one looks at 9, that's where the minister's role gets sharpened. In order to promote the purposes of the Act, the minister may, by notice in the Gazette, issue codes of good practice on black economic empowerment that may include A, the further interpretation and definition of broad-based economic empowerment, and the interpretation and definition of different categories of black empowerment entities. B, qualification criteria for preferential purposes for procurement and other economic activities. C, indicators to measure broad-based economic empowerment. D, the weighing to broad-based empowerment indicators, paragraph 6. E, guidelines for stakeholders in the relevant sectors in the economy to draw up information charters and codes of good practice for their sector. And we know the generic codes, the codes of good practices. They were developed before Minister Tao took office, from the time of Minister. It's 1960.
And when is it clear from that when it was published, when it was brought out?
What is clear is that before that. But we will deal with this point. Let me just give the court an indication of where we're going to argue on. That there was a strategy. Whether that strategy fits in with what Section 11 requires is a matter between the minister and his boss, the president. Whether he has fulfilled his functions in terms of what his legislative part do. It is not a matter which the stakeholders would worry about. We will elaborate this further. Because a strategy is a broad vision. It is not a code, it's not a guideline. It just says, as a country, we need to transform this country. We need to focus on certain areas of our economy and those who have been disadvantaged. It's a broad vision. And was there a strategy? Yes, it was. As it complies with Section 11, maybe not. But it doesn't take much further in our view. And we'll come back to that. So Section 9 lays down the principles that codes of good practice may be developed. We know as a matter of fact, so we can tick 9. There's been compliance with 9. Because we know we've got we've got codes of good strategy, of good practice. And then we go to Section 9.3.3. A code of good practice issued in terms of Section 1 may specify targets consistent with objectives of the Act. And we all know objectives is state empowerment. Means that Tao finds a train, to use the midwife scenario. The baby is being born. The functionaries in the department would prepare documents. There's been suggestions that Minister may not have read some of these things, but he reads.
Although he did not state that.
Well, if you read something and you agree with it, you don't have to write the thesis. Remember, I've read it, I've read it. Because that's not how government works. When you write to your officials, they give you a document submitted, Minister, this is what we think you should do. They take it through, you look at it, you agree with it, you sign. You don't have to write to them, or to court, or to record some, in case sometime in the future, there may be a court case in which somebody questions that you read it. So, well, let me keep this, I read it. That's not how life works. We need to be realistic about how things work in practice.
So this is the document before the publish.
Before the gazette.
Is this the only document?
No, it's a series of documents.
But this is the first one.
First. And also, you must bear in mind the timelines. Minister Tao comes into office in 30 June 2024. And at that time, there is litigation. That litigation involves on the party. When you get in parliament as a minister, you don't start at the parliament fresh. You take one from your predecessor. And generally, we have a handover. We don't know. Mr. Tao doesn't have to tell us. Like David and say, look, I met with Mr. Patel. He handed it over to me. He told me some of the priorities. One of the things might be the B-BBEE codes litigation. And he told me, he has looked at it. He doesn't have to say it. It's a meeting between ministers who are one statement. And we must be reasonable to assume SID and ET branch. There are branches that deal with transformation. There are those who deal with sector codes. And they are the experts who've been there for years before Minister Tao came to office. And this is what the submission says. Subject: approval of Gazette for the draft legal BE structure code of practice in terms of Section 9.5 of the broad-based economic empowerment amendment 53 of 2003. The leadership is correct, but that's how it should read. and it is a sector code from the amended codes of good practice. This would have been done with Minister Patel, it would have been done with Minister Tao. So it is something which happens as a matter of course. But the point is, Minister Patel was briefed, and the submission correctly shows that indeed it was briefed, not only verbally but in writing as well.
Paragraph 1.2, because it will provide an opportunity to 1.3, requesting this to consider, and the next sentence should therefore provide an opportunity to members of the public.
I'm looking at the one that sent to Minister Patel. Let's look at the one that was given to Minister Patel.
So this is not
06 station. And 4 is at 06-25. Yeah, that's it. Thank you. So this is what he's given.
this is 34.
30 August 2024. He is been in office from about June, and he's told by a branch, the Transformation Competition branch. The subject is Gazette of the Legal Sector Code in terms of Section 9 of the Act. This is what he's also told. Remember, one of the things that he must certify himself, I will come to the statement 3, he must certify himself that a proper process has been followed. And this is the checklist that he not just told. First thing, your predecessor
As complied with that.
complied. And he's told 68 written submissions were received from the members of the public. And that is compiled because must publish, must hear what the sector has said. He's then told there's a technical committee comprising of officials from the Legal Sector Code Committee, officials, and parliamentary officials. And I must say, it is deliberate that the minister comes right at the end because he can't be involved in the discussions, in the reviews, and all. Otherwise, we form.
We passed the application against the minister that will now be the previous minister, Mr. Patel. More or less which year? We can deal with it later.
Yes, I'm being given the date.
I'm just trying to work out the knowledge.
But what we can accept is when he took office, the litigation was ongoing already.
And that was not on the table, not paid.
13 May 2024, the litigation.
I beg your pardon.
13 May 2024. And the reference is 06-2. Just the date, May 2024.
So shortly before the minister took office,
On 13th of May, Minister Patel was in charge. And that is why he deposed that affidavit proposing.
I say so shortly in May of 2024, the previous minister had
30 or 2024. This relationship is quite contingent candidates. Now, the last bullet point on page 062587 says it is recommended that Minister considers and approves Gazette and Legal Sector Code practice in terms of Section 91 of the Act. It is no longer Mr. Patel. Mr. Thomas exercises power in terms of Section 91. And then if you turn to page 06-2588, there's a document called Submission Title, Gazette and Legal Sector Code in terms of Section 91 of the Broad-Based Economic Requirement Act, 1523. And of course, these are government references. They say, number one, the submission content, fact sheet. And then we have two, a presentation. We'll get to that, but what the point of the three is a fact sheet. 06-2589. It's a fact sheet. And it gives him just a broad view of what's happening. Interventions in the legal sector code and anticipated key outcomes. The sector aims to achieve a black ownership target of 50% of black women, ownership of 25% over 5 years. And they, without reading all, but they deal with its size and characteristics. Remember, he's a politician. He was, but he was an MEC in Gauteng, Community Affairs. Now he's elevated to the ministry. He's not a lawyer. He's not an accountant. He's not a builder. He's not an accountant. He's not a building. Because those sectors have got their own peculiar sector codes. There's a mining charter, there's tourism charter. He's a politician. He's not a subject matter expert. And he need not be. So they tell him, Minister, we are dealing with a legal sector code. Let's give you a brief view what this code, what this sector is all about. They tell him it contributes 0.51% GDP to RSA. They tell him the proportion and the layout. Ownership by black people is low at 25% on average. This is against the total number of 33,100 attorneys, the number of black attorneys is 16,697. They tell him there is inadequate access to the sustainable flow of quality work for black practice submission with recommendations/approval signatures. Given an Annexure A is given the legal sector code itself. And as we know from practice, if you call somebody to a meeting and want him to discuss an particular document, at least he has an idea of what. He is suggesting that he only got these documents in the meetings and never had time to read it. Okay. He didn't sign it, he didn't sign on that day. That's for sure. And then I see it's 11 of them. It's 11 of them.
We will be sitting until 11.
Okay, thank you. Thank you. It's copies.
Time has become very precious.
Time is very precious. Thank you. My clock is working. So, he's then given a copy itself, the legal sector code. It's Annexure A, Minister's Comments. This would have been the previous minister. So, one cannot say that he simply ignored Mr. Patel's comments. But in any event, on a broader scale, if you look at the requirement that he is to satisfy, he doesn't have to take Mr. Patel's views, he doesn't have to accept it. Indeed. It is not a jurisdiction. He did not take into account Mr. Patel's concerns, therefore, let's review it. That's not canon. And then they give him a application, and perhaps should go there. It is 06-2787. I see that somebody called who's keeping all of it. People are helping.
Thank you.
They're helping us to direct this very because that's all his opponent. He needs a support from the land ministry.
This letter is dated 7th of June 2021.
Yes.
That being the same, course, if I understand correctly, after the comments were received, the code was then fine-tuned to 1 to 4 days. So is this the final code that was published, that was now here supported?
This is not the final. But it must go through various iterations. But before it comes to it, the land minister must make the right decision.
This cannot be the lead. It does not make sense to me, I might be. Chronologically, this was given on the 7th of June 2021.
It's
But
called,
maybe
this is
it's not taken any further. I just
no, but
This
it's
was
important.
the letter of support from
Justice.
yes, pertaining to the fine tune.
It's, let me say the following. In broad outline, the sector goes out, prepares its own consultative process with its constituents.
So in 2021, the line Minister of Justice was already set. He supports.
He supports it. But what Justice does at SWB, he's giving a narration to the Minister of DTIC. He said, I'm supporting this because of what I've seen happen. We have seen from the first submission letter, the document right at the top, where the executive summary has been told there was a steering committee comprising officials from the DTI and from the Justice as well. So the Minister of Justice would have been briefed coming along, and his people would then say to him,
Now, I appreciate that. I just, the date of the letter was a bit confusing to me. I get it.
these are the steps that you must follow. And one of the compulsory steps is that the land minister must support. In other words, the lawyers can't simply go and camp at the Minister of Justice office away. We have
No, I totally appreciate and understand that. My only question was the date, but I understand.
And
Follow
this,
you.
yeah, this is what he says to Mr. Patel, as Mr. Lamola, at 06-2786. Says Mr. E. Patel MP, dear colleague, letter of support in respect of legal sector code. The Legal Sector Code Legal Practice Council initiated a process to facilitate the development and adoption of the B-BBEE Legal Sector Code in terms of Section 91 of the Broad-Based Black Economic Empowerment Act of 2003 in order to advance the transformation of legal profession. Until now, legal practitioners, but just to read the last paragraph, the concluding paragraph on 06-277, I am now pleased to inform you that the process has been completed, and as a minister responsible to be the policy custodian of the legal profession, I hereby offer my unreserved support for gazetting the legal sector code. I am satisfied that the aligned process has not only undergone vigorous engagement and consultation with majority industry associations, but also has been tested against the alignment principles as required by B-BBEE policy framework and legislation. And this is the Minister of Lawyers, with arms satisfied.
Mr. Patel was clearly not safe, but the Minister of Justice was.
Yes. And so this is part of this, the checklist that is given. So he's given the letter from the minister. He's then given Annex E, list of stakeholders. And it is important, and that's how I want to emphasize, it is not the minister's code, it is a sector's code. And the Minister of Justice confirms that those processes have happened. And from page 062789, it's Annexure E. It is yes, stakeholder submissions received by the Department of Training and Student Competition.
Well, I'm at least now at 968, so there were a lot of submissions. I've just been looking quickly while we referred and running down. There were a lot of submissions.
There are not submissions, indeed, and that is the point. That the Minister Tau can then ask and say, there was a submission from Legal Aid South Africa. You look at it, and you have it. You must accept that those who have got the expertise and the time and knowledge would have gone through.
At number 54 is solidarity.
Yes.
Lawning. There was also well. We know that everyone submitted.
But as far as I'm concerned, as far as I know, Solidarity Legal Network are not legal practitioners who are registered with the LPC. They may be training on members, but that's neither here nor there. But thank you, my friend. That's a very good observation. And to emphasize, this is what Mr. Tau had in front of him. And then if we go back to the table that was a list of the documents that he had to look at. It's on 06-2810. I'm looking at my computer. Let's see if somebody's not taking that.
Let's see if we try to bring
That, indeed. Correction. I said the general code that the applicants can comply, can use the general code. I told no, you can't. General codes of, so we can only use the LC. But the point remains that you don't have to use it. If you don't like it, you don't have to use it.
voluntary.
Voluntary.
Submissions are extremely valuable. You are appearing for the decision maker, aka
So if we then go to the next step that was taken, it's Annexure F, not G, Technical Committee Appointment Letters, 06-2810. And the significance of this yes, it's the other way around, which is not very friendly. And the draft legal BBBEE sector code, and they're appointed by the Acting Director General, SID and ET branch. The next one is on 062811. It's Mr. Tabo Masomboka. And then the foreign one is on 062812. Ms. Christine Kun. She was in the legal steering committee. This matter was in the legal practice council, and she was part of the steering committee. She's now in the legal sector. Melissa Mare, and then Jacob Maputa, who I'm told is dealt with somewhere in the papers, has been involved in very many charter. So the minister is not yet there. These are sector, subject matter experts who must interrogate and look at the comments raised, each one by one. And that's what they then did. At Annexure H1 is what was given to Mr. Tau. 06-2822. So they look at the submissions received and they summarize all of this. So that means that doesn't have to go through it and receive a report. What do they say? So that's what they then did. H1 and Annexure H2. This is a summary of commentary by Allen and Overy, South Africa LLP. One of the raised issues with raised comments on, for instance, on page 062829, they raised number clause 18, the ownership scorecard. There's management control scorecard, clause 19. So they deal with all these issues that we are now called, this court is now called to decide.
And the whole process has spanned over about 3 years. But then he's confronted with this document that refers to very complex substantive issues pertaining to what is contained in the practice code. Why does this write, according to the minister, when he received that? To what extent must the minister interrogate the issues? Maybe you could just elaborate. I'm just trying to understand exactly what the minister's obligation is and what he has actually done, especially regarding the substantive issues.
One thing I'm going to do is to read every submission. That's kind of. One thing he doesn't have to do is to
Someone just shining right in my eyes. Thank you.
thank you. In his affidavit of transformation charters and sector codes, and 2.1 important, the relevant sector body, together with the relevant land ministry, or the sector seeking to gazette under section 12 must. Now the Minister of Trade should come in at 2.1. We have seen Mr. Lamola wrote a letter in support, and now there was a plan in writing which they did, and another tick box. 212, provide evidence of compliance with Section 12 of the B-BBEE Act as amended. So one of the things that you may refuse arguments, and the applicant may reapply for the Consultative Charter by revising its submission. In 2.4, the Minister of Training Industry must gazette transformation in the Charter as soon as it is reasonably possible following the granting of an application.
This is a legality review part of the put that aside. If you accept this as a legality review, then when it comes to the exercise of the public power, a court has a certain approach when it looks at the exercise of such a discretion. Now that's broadly where I'm getting at this. Taking or bearing in mind that this probably is a legality review, then certain things are expected of the decision maker. And that is that context that my question is.
So let me rephrase it in upload. One man so this, in a way, it can. As I recall, it tells us what a person in the position of administration has paragraph 20. He may refuse in a grant, so it is he must accept the power. The court says if Minister of Environmental Affairs and Tourism, that is Cinematic 14, 1995, 6 SA 1 and 2. A functionary in whom a discretionary power is vested must himself exercise the power in the absence of the right to delegate. In Hoffmeyer versus Minister of Justice, another 1923 SA 1 just 117 G, King J pointed the rule is thus. It is well established that a determined power vested in one official must be exercised by that official or his lawful delegate, and that although where appropriate he may consult others and obtain their advice, he must exercise his own discretion and not abdicate in favor, be aware of the grounds on which that advice was given. But it does not follow that a functionary such as a DDG in the current case would have to read every word of every application and may not rely on the assist making a decision. He will simply to rely on the advice of another without knowing the grounds on which that advice was given. The decision would clearly not be his. But by the same token, if you apply, if you choose and you apply, and they say to you must do this and that, I'm not sure if you don't do it because one, if sometimes yes, therefore you're actually unlawful. It depends on the purpose of that strategy. What does it do in the bigger scheme of things in legal and in courts? What is the purpose? Sometimes the law will say, if you don't do X, you must be fined. It doesn't mean that what you do legally becomes 120, paragraph 120. In the case of airports, page 19, there's
I'm reading the airports company.
Indeed. So it says the peremptory nature of the B-BBEE Act, and this will be the Act, not the code. It's already been stressed in the preceding paragraphs. It is still a deviation to the sector itself. They have said that it is because of the unique circumstances of the sector that some things can be thought lavish in the general code. You have a profession where there's, you can't be shareholder in law. if you're not a lawyer. Director is something else. Because some firms are incorporated. They've got directors. Some are not incorporated. But I can't buy it. I will just buy shares in well, maybe I could, but I might have to leave. I'm not going to. They are all these regulatory. So the point is, you can't simply say, the general code says this, therefore, if you depart, you're out. And then we make a point where we say, in reference to the above case, the decision by the LSC was rational because there is a connection between the decision taken by the LSC and the purpose for which the decision was taken. We refer to the case of University of the Free State versus Africa and another. The citation appears there, footnote. I accept, however, that the decision to adopt a new policy may be subject to legality review on the ground that it was made in excess of public power. The question to be considered in this context is whether with the exercise of power simply because they disagree with the decision to consider that the lower power was exercised inappropriately. If, therefore, the decision maker acts within his powers and considers the relevant material in arriving at a decision so that there is a rational link between the power given, the material before it, and the end sought to be achieved, this would meet the rationality threshold. The weight to be given to the material lies in the discretion of the decision maker. So too does the determination of appropriate means to be employed towards this end. But if the decision maker in his constituted power, and in paragraph 151, we state page 19-247, the applicants allege that the LSC fails to be falsely reviewed and be set aside on the basis that it constitutes an unconstitutional measure under section 9 of the Constitution and with the sense. And I hear the issue was how you look at the points that the whole scoring mechanism falls, but that can't be. Let's say, for instance, the court says you should have included the socio-economic element.
Thank you, Mr. Nalani.
Thank you, my lady. The documents which set before Minister Tau, I just want to refer the court to one of those which are important, and the court can, in its time, go through that. It is the Memorandum on Deviation from the Generic Codes of Good Practice. It is at 06-3168. And so this formed part of, the court will remember that I was using an extract from the page that accompanied the memorandum,
Yes.
the index which indicates the annexures. So as part of that pack, we said before him was a memorandum of deviations, which showed why there were deviations and all the issues about socio-economic and all
Were
manner of
addressed,
deviations.
was addressed.
So he had an understanding of why those deviations would have happened, and also as part of the deviation exercise at 06-2687, no 37.
Yes.
Paragraph 6.3. Minister's comments on the LSC deviations. The previous minister considered the
Where are
LSC,
you reading from?
paragraph 6.3 in the middle of the page.
Oh, it is submitted with the LSC, if formalized. Are we on page 06-2866?
No, I'm sorry, 2637.
2637.
Yes.
Thank you.
And it says the previous minister considered the LSC and the motivation for deviations and raised comments and concerns which were informed by two legal opinions. The minister then wrote a letter to the LSC steering committee and also had a meeting on 7 June 2024 to seek clarity on the following: whether deviations in the draft LSC from generic codes in respect of weightings and thresholds meet the test for deviation, and other objections of a substantive nature. Next bullet point, whether the deviations are supported by any material evidence based on either sound economic principles, sectoral characteristics, or empirical research. The legal opinions related upon by the minister's decision are attached herein as annexures J1 and J2. So in case he had to understand better what those legal opinions say, he's given the annexures. And then 5.4, revised LSC and amended memorandum of deviations. On 15 July 2024, the LSC steering committee submitted and revised and amended LSC and memorandum of deviations which addressed the minister's concerns, and the comments marked Annexure K, as well as legal opinions marked Annexure L, 3 LPC 2024, statistical reports on the size and demographics of law firms.
That was recent. It was a recent statistical report.
Indeed. Okay. But I think the point is that there's a memorandum of deviations. It explains why there were deviations. And so one cannot now second guess and debate the specifics of the deviations. Comments were received, deviations were justified on paper.
Rightly or wrongly?
Rightly
it
or
was
wrongly.
justified.
Indeed. And the court, we can't then pull down the whole house because the steering committee thought this way or the other way. So those are that's the point. And then if I just deal with maybe 1 or 2 points raised by my other friends, that the role players sought to absolve themselves of responsibility. It's one submission that was made. Everybody seems to be saying, no, it's not me. Look at the same concern.
We do not have any record of meetings or what was said at the meetings.
But the point is that we have seen from the record that there was a steering committee. We have seen on the record that there's a technical committee. We've seen on the records that the minister met with some of the committee members. We've seen on the record that the Department of Justice played a role, as they should have. They wrote a letter to the Minister of DTIC asking for the gazetting. We've seen the Minister of DTIC, the midwife, deliver the baby successfully. And so there's no ground really to criticize the Minister of DTIC. And I'm about to wind down now. My learned friends for the other parties, for the first, second and third respondents, will deal with other aspects that need to be dealt with, especially on the roles that their clients played in this chain of events. And then, before I close, court to recall, I mentioned a bit about the South African War, so-called Anglo-Boer War, in the past, which is a part of our history and shaped us where we are now. Incidentally, one of the commandos in the Anglo-Boer War was a gentleman named Dennis Reitz, famous lawyer. His name prevails even today, and his firm is one of the applicants.
Full circle.
Full circle. With those are our submissions, and we would ask that the application be dismissed with cost. No cost.
No cost.
Every lawyer understands that. With cost is almost automatic. Without cost.
Thank you.
There's a cost.
Then it's Advocate Bukaka.
Bokaba.
Mukaba.
Bokaba. B-O-K-A-B.
Advocate Mukaba.
Bokaba. We agreed to swap roles for practicality purposes. My learned colleague, Mr. Matebesi, will give his presentation.
Thank you.
Thank you, Justice.
I thought all the respondents were on the right.
I always like to play for both teams. I'm joking. Justices, even today, as we had done in the process of the adoption of the code leading to the promulgation of the code, we play a middle role. We were in the middle of the stakeholders when the sector code was drawn, and we played a middle role between the stakeholders and the Minister of DTI. Even today we play a middle role that will come and say, let's argue before the stakeholders. It is in that context that we come as the Minister of Justice and Constitutional Development. Ours is more of giving a purpose to the entire exercise of drafting and the promulgation of the legal sector code. We do that because our understanding of the rationality test as articulated in the New Africa Duty-Free Shops Pty Ltd judgment will refer the court to the relevant paragraphs, is that this court must look at whether there is a rational connection between the act and or the method used and the purpose for which it is designed to achieve. Is there a government purpose that is sought to be achieved by the LSC? Perhaps for us to be able to deal with that properly, we need a context. And this is what we are going to deal with first. The context requires us to go a little bit backwards and look at why in the first place does South Africa need to have all these measures of transformation, the legal sector codes, the finance codes, and all that. We have referred the court in our heads of argument to the Belpoto judgment, but I want to start with what has been written by Mogoeng CJ in the matter of Tshwane City versus AfriForum and another. In paragraph 2 of that judgment, he gives us an essential context. Fortunately, he was dealing with the same kind of clause that we are dealing with, which relates to discrimination, or call it racism, call it inequality, but it goes back to the same principle. Here's what he says. South Africa is literally the last African country to be liberated from the system that found nothing wrong with the institutionalized oppression of one racial group by another for no other reason but the color of their skin, shape of their nose, and the length and texture of their hair. This is the system that the United Nations declared a crime against humanity. It is the same system that says to us, we must go back as South Africans and see how best we can resolve it. But we say, we are here firstly because there are people who don't want to give away the privileges that have been given by that crime against humanity. We are saying to the court, it is that context that we must keep in mind. How do we take away the privileges that those that have obtained under the system of apartheid?
Would that privileges be ownership?
Is the ownership and the empowerment economically that they have. It is important then to have that context. He goes on and says, he says the underlying reasons advanced for this irrational differentiation was that African people in particular and black people in general were intellectually inferior, lazy and lesser beings in every respect of consequence. As a result, there hardly was any city, town, street, or whatever, because he was dealing specifically at that time with the naming of the cities. But what we say in the context of what we have to deal with before this court, there was literally no opportunity that was given to a black person because he is considered inferior, lazy, and less of a human being. So if we understand this from that context, then it takes us to why then was it necessary to come to these measures. Then he goes on in the judgment to say, to quote the preamble of the Constitution of the Republic of South Africa. I want to go to paragraph 9. He says, our shared values that underpin our constitutional vision, after he has dealt with the preamble to the Constitution and all that, he says, our shared values that underpin our constitutional vision cannot be achieved when one race almost always has its way or a near absolute monopoly in respect and honor. That is a recipe for illegitimate retention of exclusive privilege, undeserved domination of the past and future hostilities as opposed to inclusivity, reconciliation, and the unity in diversity we have undertaken to pursue and achieve. He says no measure of sophistry, contortion, or strategy ought to be allowed to entrench any form of racial domination or exclusivity to privilege, honor, and opportunities. For that is inconsistent with our foundational values and a constitutional vision. South Africans of all races must unite to secure a brighter, peaceful, stable, and prosperous tomorrow by allowing the previously excluded groups to also be honored in their own land. They too should at long last have a sense of belonging. We come before this court to defend a policy that is designed to empower a black person. It recognizes the fact that a black person has been excluded for decades. We have, I'll refer to the first applicant as Norton Rose. I don't intend any disrespect, but it is a name that I'm accustomed to from the papers. We have Norton Rose, who say in their papers, they have got, at the level of their compliance with transformation, they can only quote a 7% of women. They can only quote a 25% of blacks that are at higher levels of Norton Rose. We have the 4 other law firms who are conspicuously silent about their racial demographics in their firms. And they come before this court to say, we want this court to declare this code to be a code that is, in their words, irrational, a code that is illegal, a code that infringes on the Bills of Rights, because that's what my learned friend said. He said the exercise of power is constrained by 3 things. It must be lawful, principle of legality, it must be rational, that's rationality, and then it must comply with the Bill of Rights. So we give this context because we need to understand where we come from with this. We need to also understand where we are going with the attempted transformation. We are alive to the fact that they do say in their papers, no, we are not against transformation. In fact, that's what all of them who are against transformation would say. They say we are not against transformation and put a but we want it to be lawful. That's what they say. But one must not listen too much to what they say before the but, because it is not a reflection of what they do on the ground. They are happy to say they have a level 1 B-BBEE status. A level 1 B-BBEE status that they attained through the generic codes, when their numbers speak and give a picture that is far away from transformation. It is far away from transformation. They say we have complied because to them, transformation is about the level of BEE that they acquire. To them, transformation is not about physical human beings occupying positions of power within them. To them, it is only about rands and cents that they can be able to acquire from having black people within their organizations. That is not what our Constitution demands. That's not what our Constitution mandates us to do as the government. Because this court would be aware of the fact that Section 9(2) of the Constitution creates a specific mandate. And it is imperative upon the government to design measures that are to redress the inequalities of the past.
That is why we have the Act. That is one of the manners in which government addresses, or the legislature addresses this problem.
Yes, that's where we're going to go ultimately in this exercise that we're in. We're going to engage in the process of understanding where the Act is located in this and what is the proper interpretation of that legislation. But we give a context. And he goes on, Mokgwen CJ, in paragraph 14 to say, our constitutional vision militates against a never-ending determination to oppose change. I'll stop there because it goes on to deal with the names of the cities and all. If our constitution militates against a never-ending determination to oppose change, it is what mandates this court to look at this legal sector code through the eye of the Constitution, to say, does this code serve a legitimate government purpose viewed within the context of the Constitution, the history that the African people in South Africa comes from, and the motive that was behind the sitting of the people of South Africa as a whole to design a constitution like the one that we have. If then we have that at the back of our minds, then we're going to be able to understand properly and be able to properly interpret whatever legislation that comes in support of that imperative that is within the Constitution. So it is for that reason that we say it is important to take a leaf from what the Constitutional Court says in that Africa Forum judgment. In our submissions to the court, we intend to touch also on the purpose and the object of the B-BBEE Act, the proper interpretation of Section 2, 9, and 10 of the B-BBEE Act, the legal sector code and its purpose, and to the extent necessary, the generic codes that reliance is placed on by the rest of the applicants. We will give the court an understanding of what the general codes are. We will also touch on the arguments made by the applicants, in particular to the binding effects of certain clauses in the generic codes, which are which there's an argument that says they are peremptory because they use the word must instead of may and all that. We will deal with those issues and tell the court why those are inconsistent with the bigger scheme of the generic codes as a whole. As we have indicated, my ladies, at page 021296 of the papers, that is our answering affidavit.
Just repeat, 02
02-1296.
1296.
That's why we quote Charles Cassin CJ in Belpoto. We're dealing there with the need for transformation, which is at the core of the involvement of the Minister of Justice in this whole exercise that we have today. She is involved because she is in charge of the legal sector of the legal sector. She is alive to the disparities that occur within the sector and that are in the sector. She is alive to the inequalities and to the unequal treatment of black people, in particular women, within the sector. And that's why she feels strongly that she must be part of these proceedings, irrespective of what is argued before this court to the effect that the main relief is sought against the first respondent only, and no one else must speak but the first respondent. Unfortunately, we hold a different view insofar as that is concerned. In paragraph 15 of our answering affidavit, page 02-1296, as we said, we quote from what Charles Cassin CJ says in the Belpoto School Governing Body. He says, in 1994, when the interim constitution came into force, ours was a grossly unequal society. The interim constitution was designed to create a new order in which there is equality between men and women and people of all races, so that all citizens shall be able to enjoy and exercise their fundamental rights and freedom. He says this commitment to the transformation of our society was affirmed and reinforced when the constitution adopted by the elected Constitutional Assembly in 1996 came into force. And then he says the preamble to the Constitution recognizes the injustices of our past and makes a commitment to establishing a society based on democratic values, social justice, and fundamental human rights. Says the society is to be built on the foundation of the values entrenched in the first section of the Constitution. These values include human dignity, the achievement of equality, underline the achievement of equality, and the advancement of human rights and freedoms, and a multi-party system of democratic governance to ensure accountability, responsiveness, and openness. He goes on and says the difficulties confronting us as a nation.
Makibesi, I do not want to interrupt you unnecessarily. I think we have now a very good idea of where the context. It will be very helpful for this bench if you could deal with what we are called upon to decide.
But my lady, if we are going to do that, it means we are going to lose the purpose of the entire transformation. Because that's at the core of what we're talking about. We need to understand what is the purpose of all these codes. And that's why we have to go back to our Constitution, go back to our history as South Africans, come to the Constitution, and that clean break.
Explained up to now.
Yes.
Last 20 minutes, you really explained it very well. So I'm just saying, and we appreciate that context. That, but I'm not going to stop you.
Now, thank you very much. I'll try to hit what the leadership is saying, but obviously without disturbing the line of argument that I intended to take, because it would be an injustice to the minister not to put these issues before this court, because they are important to her. He says the difficulties confronting us as a nation in giving effect to these commitments are profound and must not be underestimated. The process of transformation must be carried out in accordance with the provisions of the Constitution and its bill. And he says, yet in order to achieve the goals set in the Constitution, what has to be done in the process of transformation will at times inevitably weigh more heavily on some members of the community than others. Because you are told that what we stand to lose as the applicants is our level of BEE compliance. We're going to drop from level 1 to level 6. But that's what the Constitution recognizes. That if we are to achieve equality, those who have been benefiting, those who are at a higher level than others, must expect that in the process of transforming the society, they will have to lose certain benefits, they will have to give away certain benefits. But if they don't give away certain benefits, then legislative measures are going to be made so that they are able to give away either through incentives, as my learned friend has said, or through force. But the focus is never the incentive. The focus is the transformation. But the incentive is a mechanism of reaching that transformation. So we can't focus our eyes on the level of BEE. We must go beyond that. It is not about the BEE level. It is about whether this sector code is designed to achieve transformation. It may do so through giving incentives. It may do so through criminalizing certain actions. It may do so through other punishment. But the main focus should be
Transformation.
What is behind that incentivization. We can't end at level 1 BEE, because we need to ask ourselves as well whether this level 1 BEE that we are giving to Norton Rose, that we are giving to Weber Wenzel, this level 1 BEE compliance, does it achieve the objects of the transformation? If it does not, then we fall foul of Section 9(2) of the Constitution, because we are not focusing on what the purpose of this exercise is, but we are focusing on incentivizing people. So that's why it is important to understand what is it that is behind this incentivization, so that we can go there and put our measuring sticks at the purpose that is behind the incentivization, not on the incentivization itself. So that's why we feel it's very, very important that these issues must be brought. We emphasize that transformation is a constitutional imperative. That is clear from the Constitution. And that the express language of the Constitution of the Republic of South Africa puts transformation at the center of the constitutional project. We also want to bring in here one other important aspect that is very, very important to the Minister, which are the provisions of Section 174 of our Constitution that relate to the appointment of judges. Section 174 of the Constitution requires, it states in particular, subsection 1 says, any appropriately qualified woman or man who is South African citizen, who is fit and proper person, may be appointed as a judicial officer. Subsection 2 goes on and states that the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. Then the question that you must ask yourself is, how do we achieve this? Do we achieve this by incentivizing people who have 7% women that do not contribute any way to the purpose of Section 174 of the Constitution, because they have got only 7% of women out of their entire setup? They have 25% of blacks out of the entire setup that they have in an international organization or entity like Northern Rose. They only account for 7%. And the object of the Constitution is, from that Northern Rose, we expect to have women of high quality. We expect to have blacks of high quality that are going to be able to preside over the affairs of South Africans. And if we can't get them, what is the object of then incentivizing them with a level 1 B-BBEE? It makes no sense. It makes no sense whatsoever. So the point we're making is this: South Africans, both urban and rural, they need a judiciary that they can resonate with. We say the color of the trier of fact matters to the people of South Africa. Why does it matter? It matters because we are coming from a traumatic past as South Africans. It matters because our traumas can only be alleviated when we get to court situations when we see a person of our own color, of our own gender, sitting in front of us and presiding over our cases. It's so important to us to achieve this transformation. That's why we emphasize the point that it is never about rents and cents. It is never about level 1 B-BBEE compliance and level 6 and tenders. That's not what we are concerned about. That's not the purpose that we want to achieve. So when you are going to deal with the rationality of the LSC, that's what we want this court to keep in mind. That Section 9(2) of the Constitution demands of us to set up measures that are going to achieve equality for the people of South Africa. Section 174 of the Constitution calls upon the people of South Africa, when they are electing judges to the highest positions of the judiciary, to take into account that this person is a fit and proper person. He is fit and proper because he has got the qualifications to be there. And he is also fit and proper because he understands the dynamics of the people of South Africa. And above all, it requires that it must reflect the demographics of the country. Why must it reflect so? We say it is because when a black person from Elliot Dale in the rural towns comes before a judge, he must be able to see a judge that he resonates to, and he's able to become confident and comfortable that the person who's presiding over his matter will understand the living conditions that he comes from in the rural areas. That's why the sector code, to some extent, demands of these big law firms to improve and have people from the rural areas to be part of their management, people from the rural areas to be part of those people that are developed by the law firms. Because, why? That person from the rural areas is the only person that understands the living conditions of the people in Nkandane. So it is important that transformation must happen. It is important that transformation must be at the forefront of what we're talking about here, and not the BEE levels.
Yes. Do you mind?
So having said that, then we proceed and deal with the B-BBEE Act. The Act, as its name suggests, is for economic empowerment, and in particular, economic empowerment of blacks. We will engage in the process of interpreting the legislation. I just want to open it, if the court would bear with me in this regard. The preamble to the Act, you have been taken to the preamble to the Act. It recaps these important issues that I've canvassed with the court. The inequality that we live under 30 years after the Constitution, because it still applies even today. There's still inequality in South Africa. We can't shy away from that. And it then speaks to the exclusion of a majority of people of South Africa from the economy of this country. This Act is directed specifically at that. If one looks at the objects of the Act, you will find them in Section 2 of the Act. It says the objects of this Act are to facilitate broad-based black economic empowerment by promoting economic transformation in order to enable meaningful participation of black people in the economy. It does not only require participation. It describes this kind of participation that it wants to achieve, which is a meaningful one. It says we require a meaningful participation, not a toy person that is going to be put at the corner of a boardroom by the board of directors of whatever company, and his name be endorsed on the attendance register, and then thereafter he's excluded from the discussions that are taking place, but the only thing that reflects his participation is just the attendance register and nothing else. That's not what the BEE Act was.
What you're addressing us now, is that factually based? Is that...
No. I'm assisting in the interpretation of what we are saying. In interpreting that, what the Act envisages in meaningful participation. It does not envisage a situation where a person is rented to sit next to the board of directors of a company solely for the purposes of ticking a box. It means he must meaningfully participate. The LSC is meant exactly for that, so that there is going to be monitoring of that meaningful participation of black people within the establishments, in the economy of the country. It is meant to achieve economic empowerment by achieving a substantial change in the racial composition of ownership and management structures, and in the skilled occupation of existing and new enterprises. We deal with this because it is important to do so, because it is in understanding those objectives of the Act that we are able to understand and also test the rationality of the LSC. Because the LSC is a child of the B-BBEE Act. The B-BBEE Act is a child of the Constitution. So it is important that this context be in mind to everybody who's going to interpret and understand the rationality of the legal sector code. But what is important is that we need a substantial change in the racial composition of the management and ownership. And as a result, legal sector code, you would have seen, it incentivizes management differently from ownership. And there's a reason for that, because these are different things. I heard my learned friend, one of the applicants' counsel, arguing that there's a conflation of ownership and management in our case, or in the legal sector code. There's no such. The legal sector code treats management differently from ownership. And ownership, it refers to it as board participation.
Yes.
And then management has got its own points. So that's why it says we need a substantial change. You have heard argument here that talks to the irrationality of excluding certain people from board participation and from ownership. They say we exclude certain blacks who are not lawyers from management and participation. But the point of the matter is this. If you view it from the Equality Clause, you view it from Section 174, you view it from the objects of the Act, is it really irrational to say, if we are to achieve the objects of transformation, at least in the legal sector, we must make sure that what we transform is lawyers? We don't take anything away from the fact that these big corporations have got managers who are IT specialists, who are accountants and all that. But that's their business. That's the running of their business. It simply has nothing to do with the legal profession. The object of the legal profession in the legal sector code is to transform the legal sector. Because it doesn't help us to take a lot of accountants and incentivize a person for having had 10 accountants in a board of directors constituted of 12 people. And we incentivize him and say, we're giving you the biggest score in BEE because you've got so many bank directors who are accountants. But does it serve the ordinary citizen of the country who requires a judge of competence who must sit there and preside over his matter? It does not. Does it serve the economic transformation of a black lawyer? It does not. So that's why we say this is important so that we can be able to understand where do we come from as the government with all these initiatives. Why is it necessary to engage in all this exercise? Why is the legal sector code in our submission so rational that you ought not to interfere with it? The plight of women has become so important in our country because they have been the forgotten part of our society. It says increasing the extent to which black women own and manage existing and new enterprises, and increasing their access to economic activities, infrastructure, and skills training. You see, it expands a little bit when it gets to women, for a reason. They have been excluded for quite a long time on many of these aspects that are covered there. You have a Weber Wenzel that says, I'm not going to tell you, court, how many women do I have in my establishment, but I'm prepared to come to you and ask you to defend my level 1 BBBEE certificate. And they say, because it is rational for me to hold this certificate, despite the fact that I don't tell anyone how many women do I have, but I must obtain that statement under the BBBEE Act. Does it correspond with the object of the Act? It does not. That's why we feel so strongly about these points that we are making. And you have a Norton Rose that says, I have only 7% of my entire management that is made up of women. But one thing that we must not forget is that these organizations and these entities, they have existed for quite a long time, long before we had our constitution. if they were willing to voluntarily transform, they would have done that before the B-BBEE Act was enacted. They would have done that in the 23 years that the B-BBEE Act has been in existence. But they come to this court and cry and say, no, the period that we are given is very short. But what about the period that is passed from 1996 until now? Do you account for that? No. They want everybody to understand the case from their own perspective, not from the prism of the Constitution and the B-BBEE Act. That's why it's important for us to bring this context so that this court keeps it in mind in deciding on the rationality issue that they have raised and they are relying on. Because there's no explanation whatsoever why big firms would still be having 7% of women after 30 years. There's no explanation. Why a Weber Wenzel cannot tell us how many women they have in their establishment after 30 years. I'm not talking about the period that they've existed before the Constitution, because they still had an obligation anyway if they aligned themselves with the plight of the people of South Africa. But they never. So they want to be forced into doing these things and then complain when measures are taken for them to be called upon to at least relinquish the privilege that you've obtained under the apartheid laws. Return that privilege. Give it to the people that it belongs to voluntarily. That's the sensible thing that you should have done. You come to court when the LSC is enacted and you say it gives you shorter time frames for you to be able to comply. My lady, I want us to go to then Section 9 of the Act. Because I want us to go to Section 9 because it is where the power where it deals with codes of good practice. Codes of good practice. One, we need to understand keep in mind when we have to deal with this, the cardinal principles of interpretation of statutes. We must give the language that is chosen by the legislature some importance in interpreting the legislation. We must also interpret the legislation purposely, and we must also not forget the context that is applicable to the legislation and interpret it as a whole. That's the tried principles of interpretation. But importantly, I want us to start with subsection 1 of Section 9. It says, in order to promote the purposes of the Act, that's the reason why the minister is given that power. In order to promote the purposes of this Act, the minister may, by notice in the Gazette, issue codes of good practice on black economic empowerment, and that may include, we'll skip the rest of the others and go to subsection E, guidelines for stakeholders in the relevant sector of the economy to draw up transformation charters and codes of good practice for their sector. I want us to first identify what's the role of the minister in Section 9, subsection 1E. It is to gazette codes of good practice that would give guidelines for stakeholders in the relevant sector. What is the purpose of the guidelines? The purpose of the guidelines is to help the stakeholders in the sector to draw a code. That's the proper interpretation of that section. It doesn't say the minister may draw up a code and gazette it himself. It says no. The power to draw a code is not yours. You issue in the Gazette a notice that would give guidelines. And then that's all. Who draws the code? Is the stakeholders in the code. But they do that through the guidelines that are given by the minister.
The guidelines in this instance, would it be statement 003?
Yes. That's what he did in 2013, 2015, and issues those guidelines through a gazette. That I've given you the guidelines, then you can go and develop your sector. You draw up your sector code.
So the guidelines...
This is important because you were told in argument that whoever is here, except the minister of the TTIC, is irrelevant. But the main focus of these people the applicants, the main focus of one of the main points that they come up to this court to seek relief, one of the main reliefs that they seek, Weber, Wenzel, and others, is the setting aside of the code. A code that is not drawn in the wording of the legislation by the minister of DTIC. Yet they come and argue that everybody else who's seated here is irrelevant. We will take you to a document that tells you, a memorandum that was written to the minister, that tells you who were the stakeholders that way. I think my learned friend had taken you through that.
Yes, we've
for
already
the minister.
seen that, yes.
And those stakeholders that are identified in that document, they include all the associations that operate in the legal sector. Those are the stakeholders that the Act refers to. But we are told on a point where the applicants want the setting aside of a document that was created and drawn by those people, that they must be excluded because they matter not. They do matter. The minister does matter in these proceedings because the minister was part of the stakeholders. That had to be. He sent delegates to go and sit as part of those stakeholders to draw up the sector code. There is a reason behind that. Because those people, as my learned friend had submitted to you, those who are stakeholders have got the expertise and the knowledge that is better than that of the minister of the TTIC when it comes to matters that affect the legal sector. There is a reason for that. And then this draws us to one point that we make in our heads of argument. We say, with reference to the Constitutional Court judgment by Khampempe J in the B-BBEE Mamwana Traditional Council, that where the right to just administrative action, okay, let me go to the relevant part of our heads of argument. If the court would just bear with me a little bit. We say the right to just administrative action under PAJA and Section 33 of the Constitution does not say to this court, you must substitute your own decision. It says at page 25 of our heads, it's 19-302 on case line.
Thank you.
Paragraph 65. We refer there to a judgment of B-BBEE, Marota, Mamone versus the Commission on Traditional Leadership Disputes and Claims, where the Constitutional Court, with reference to the standard of review by Khampempe J, says amongst other things, our right to just administrative action and PAJA, the legislation enacted to give effect to that right, require rigorous scrutiny of administrative decisions. Importantly, she says, but neither ask courts to substitute their opinions for those of administrative bodies. It is not required that a decision of an administrative body be perfect or, in the court's estimation, be the best decision on the facts. And this is particularly so for rationality review under PAJA. And then they go on and quote Hoekstra. And then she goes on and says a level of deference is necessary. And this is especially the case where matters fall within the special expertise of a particular decision-making body. We'll end there for the moment and say, the legislation deliberately says stakeholders in the legal sector, or in whatever sector for that matter, finance sector, accounting sector, go and draw up a code of your own. Because you better understand the intricacies and what is required to be there in that code. You better understand it than the minister who's responsible for this act. You better understand it than any other person who's an outsider in the sector. Go and draw that code and bring it to the minister for the minister to publish it in the Gazette. That's the role of the minister. So the point we're making is this. Even if you are asked to test the rationality of the legal sector code under PAJA, Section 33 of the Constitution, you still have to exercise a measure of deference and recognize the fact that,
Separation of powers.
and recognize the fact that the stakeholders that drew the code know better than me. I'm not going to refer to somebody else. They know better than me. So I'm not I must give deference to what they have done. So that's why it becomes important. But then going with the scheme of the act, we're still on the interpretation of the act.
So what the minister published, it wasn't guidelines this time round. It was a code of good practice.
What he published now is a code that was drawn up by the sector.
So 9.1e, the guidelines to stakeholders, that is not, well,
This is what they call the generic codes. This is what they call, they argue is binding on the stakeholders when they
this time
prepare
round,
their
it
code.
is in terms of Section 91, Code of Good Practice.
Yeah.
Thank you.
So if we go down with the scheme of section 9, after the code has been drawn up, then it gets to be presented to the Minister of the DTIC in terms of section 9.5. It says the minister must, before issuing, replacing or amending a code of good practice in terms of subsection 1, publish the draft code of good practice or amendment in the Gazette for public comment. This is what the minister has taken you through and shown you that he complied with in September 2024. It says, paragraph B, grant interested persons.
This was complied with prior to the publishing of the code, because the code was first published to get, as I understand it was first published to get public comment within 60 days.
Yes, yes,
And this code was published as a final code.
yes. So the publishing of the code occurs under section 9.5
Yes.
of
The draft code.
of the act.
No,
So
that is
so the
draft.
gazetting of the code also arises. That's where the power to gazette the code is.
Section 9.5
9.5.
says the minister must, before issuing, publish a draft code. So this code, and I might be wrong, if I understand the wording, if I look at the words, then section 9.5 pertains to the draft code and not the final code.
Yes, I accept.
Thank you.
So I'm going to deal now with the provisions of section 10. Let's leave for a moment. Let's go to the provisions.
Council, it will be helpful if you can maybe just give us your sense or your opinion on section 9.2, because there was quite a lot of this, there must be a strategy and must or mustn't be. what is your view on that?
Yes, that's so important. I nearly missed that. It says a strategy issued by the minister in terms of Section 11 must be taken into account in preparing any code of good practice. The argument we make in this regard, firstly, is this. That provision, in its own terms, does not say a code of good practice or a sector code cannot be published if there's no strategy. It doesn't say that. You can read those terms on it doesn't say that. All that it requires that must be done.
Account.
What it says must be done is to take it into account. You must take it into account. But it doesn't say you shall not publish a code without there having been a strategy published by the minister. If the legislature had intended that, it would have specifically stated so. Because it is important for the purposes of the validity of a code. They would not have left it open like that and not legislate on that issue. So importantly, we must give meaning to what the legislature said and what the legislature intended.
So
all that they intended is that the minister must take into account a strategy issued in terms of Section 11. When
so the must is not peremptory. It is if the minister feels like it.
That's the submission we're going to make to your ladies.
Thank you.
That the must that is used in that section is not peremptory, because not every statute that contains the word must, or a provision that contains the word must, necessarily leads to an invalidity if you have not complied with. You've got to look at the statute as a whole, interpret it purposefully, get to understand whether the legislature had intended to visit that with a nullity or an invalidity if it is not complied with. I'm just looking at my notes.
The choice of words of the legislature might just be unfortunate.
I'll give you a authorities on that, my lady. But it's just that I just have to look at my notes. I know I had written them somewhere in. Yes, the first authority for that is a decision of the Supreme Court of Appeal in Kisimane and others. It's NKI. SIMANE versus Santam Insurance Company Ltd. It's a 1978, Volume 2 SA, 430 in brackets A at 430 in brackets A at 435B. The second one, where this principle was also considered, is the Premier Western Cape and others versus Overbeck District Municipality. It's also an SA judgment, 2011, Volume 4, SA, 441, especially paragraphs 47 to 50 of that judgment. Paragraph 47 to 50 of that judgment. The SA discusses there, and the SA comes to a conclusion that not every provision that has the word must necessarily is peremptory to the extent that
it's just unfortunate.
Its non-compliance leads to an invalidity.
The legislature, but in any event, for whatever reason, use that word.
Yeah. To give context, as far as I could remember, the Western Cape judgment, it involved a municipality that did not submit its budget on time, when the legislation says it must submit it within this period. And the SA said, no, it doesn't mean that everything is gone. They can't. The use of the word must there on the interpretation of the legislation cannot mean that they are precluded from submitting a budget 7 days after or 7 months after the period has expired. So we should not be married to the use of the word must and simply jump to a conclusion that it is peremptory, such that non-compliance with it is essentially or is necessarily an invalidity.
Invalidation.
An invalidation of must lead to an invalidation of the act. So that's our submission on section 9.2. Above all, we also want to make a submission to this court that says, to the extent that there is argument that says the strategy in terms of section 11 was not there and had not been adopted at the time the legal sector code was published by the minister or gazetted by the minister. What we then need to do as this court in interpreting that legislation, we must take that provision of the Act, we must take into account this. The principle that says the law does not require one to perform the impossible.
The law does not require...
Does not require one to do the impossible. If we accept as a common cause that the strategy is not there, taking into account the strategy as required by the section is an impossibility if the strategy is there. But does it then lead to an invalidity?
If this is what the Act, and I hear you on the must, because section 11 also have a must, but if that is what the Act provides, or what the Act wants you to do, shouldn't the decision maker then explain and say, the strategy was not taken into account in terms of section 9.2 because, or is it not necessary?
No. You would have noted that what the minister says is that there was a strategy, albeit that the strategy was before the B-BBEE Act was enacted. That's what he says. It was there in the website.
And that was because from the record, we cannot see all of these steering committees that anyone refers to this strategy. That's just why I'm a bit confused. So was it taken into account?
And my understanding is that he does state that it was taken into account. But the question is then, if, as I indicate, the strategy, we come to a conclusion, or this court comes to a conclusion, that says there was no strategy under the B-BBEE Act that had been adopted in terms of section 11, such that then that provision becomes impossible to comply. The submission we make is this. On your interpretation of that section, you must take into account that, one, the absence of the strategy does not invalidate a code on the wording of the legislation.
Yes.
Two, a principle that says the law does not require the impossible. The law recognizes that if it is impossible for you to perform or to do a particular act, you should be excused from doing such.
And then one should just explain it. The problem is we are not a legislator, and you know that very well. The court can only apply the law. We are not allowed.
I'm inviting you in the interpretation and application of that section to take into account these principles that I'm giving and these considerations in interpreting and applying that section. Take into account this. In the event you arrive at a conclusion that says what the minister says he had considered, which was adopted before the B-BBEE Act, in the event you find that that was irrelevant or it was of no consequence because it is not a strategy adopted under section 11 of
and
the Act.
it is in the papers, and I will find it,
Yes.
that the strategy was considered.
Yes. I think
Could you maybe just direct my attention to that, because we've now gone through all these committees and what was done. I did not see the word strategy.
I'm not going to be able to point to a particular paragraph, but what I understand, the argument that was advanced on behalf of the minister, I may quote it wrongly. I don't want to commit that I'm accurate in my recollection of what the argument was. It was that there was a strategy that was there prior to the enactment of the B-BBEE Act, and that strategy was a public document that was on the website. I don't want to commit and say he does say that he took that into account.
Now I appreciate it.
I don't want to commit myself to that. That's not. I can't be able to point
No.
you to that.
Thank
But what I do want to make a point on is, if a conclusion, as I say, is raised that there was no strategy under Section 11 of the B-BBEE Act that had been adopted, therefore, it must follow that it was impossible for the minister to take into account. Because remember, all that is required. Because remember, all that is required is him to.
I'm just concerned that this act, Section 11, tells the minister to issue this. So the impossibility is created by the minister. That surely cannot be good enough to say, I have, in terms of an act, I must do something, but I'm not going to do it, and then I'm going to say, there's an impossibility. I don't think that is correct.
It's actually a huge jump to arrive at a conclusion that says the impossibility is created by the minister, with respect, because we don't have a case that says this is the reason why the strategy was not there. And it can be attributed to the minister that the strategy. The act may say the minister must issue a strategy.
Yeah,
But the preparation of that strategy is not necessarily an exclusive act that must be done by the minister. It may involve a lot of other people that have to contribute to the preparation of that. So we can't jump and come to a conclusion that it is created by him, the impossibility.
No, it's not created by him. The Act says he must publish. Just as the Act says the minister must publish a legal sector code. So all that work that was done for the legal sector code, I do not know, and it's not before us, why that was not done in terms of a strategy, but we do not have to inform.
I'm happy that the leadership understands the point I'm making, that we don't have that case before us. We don't have facts upon which we can arrive at a conclusion that says the impossibility is created by Matebes or is created by whoever.
No, it's disconcerting because the minister is the one that must implement the Act, but let's leave it in.
But the point we are making then here is simply that the non-compliance with that Section 9(2) does not necessarily invalidate the code, because there's no, on any interpretation of the legislation, there's no way where one can arrive at that conclusion that it invalidates the code. The use of the word must and all that, we've addressed that issue and said
Yes,
it doesn't necessarily,
reference to the case.
it doesn't necessarily denote that any act done contrary to it becomes an invalidity, must be visited with an invalidity. So, my lady, her ladyship has already taken me to Section 11, to provisions of Section 11. I don't think there's anything more that I would want to say on the provision of Section 11. Then we deal with the code and its purpose. We don't intend to be very long in getting into the.
It's quite a hefty document.
But before we go there, before we go there, I think it's important that I refer you to what we capture in page 021303, which is the rationale for the legal sector code and all that. We simply refer you to that, so that you take note of the rationale for the code that we have outlined. My learned friend for the minister has taken you through the process of the LSC to the extent that it relates to his role, or the minister of Trade and Industry's role in the.
It actually gets to the Minister of Trade and Industry right at the end. Well, not right.
Yes,
when he must, the first publication, a draft publication, and then there's commence. So the minister is involved, but the work is being done by someone else.
My lady, then the code, you will find it at 021372 of case lines.
Thank you.
In its own terms, it gives a background that speaks to what we had given to this court as a context for why it is important to have the code. In clause 2, it refers to a vision of the code. And it says in express terms, the aim of and objective of the LSC is to transform the legal sector in order to give effect to the objectives of the Constitution of promoting effective and sustainable economic participation of black people in the general economy of the Republic of South Africa, and in particular, the legal profession. It restricts us and says, look no wider than the legal profession for my application and for my vision as the legal sector code. Then it takes away the arguments about the non-inclusion of non-lawyers.
Non-lawyers.
Because members of the legal profession, by definition, in the LPA, they'll only be lawyers, in particular advocates, attorneys, and to some extent candidate attorneys. But importantly, the LPA would be
It's
talking.
very dangerous. Candidate.
But I don't remember it referring to candidate attorneys specifically as members of the legal profession. But we do know that they are part of the legal profession. But what you do not find in any definition anywhere of a legal professional is a person who's an accountant. You don't find that in any definition of a legal profession. So if we're talking about a legal profession, we must then keep in mind what the vision of the LSC is.
Because if I understand your submission correctly, if one include all these other support systems, then one is not transforming the legal profession.
It defeats the object of the transformation of the legal profession. Because now we are going to say I've got a bag full of apples, when in actual fact apples are 20% of the full bag. And simply because it's written on the outside apples and it's got a picture of an apple, and we say it's full of apples, when in actual fact it is not. We want a true reflection of what it is that we're dealing with. That's why the legal sector code has got a vision, and that's why the economic transformation is defined in the legal sector code with a particular purpose in mind. The question that this court must first ask itself, therefore, when it's dealing with the legal sector code is, does this vision of the legal sector code align with the equality clause in the Constitution? Does it align with the B-BBEE Act? Does it align with the general objective or the purpose that is sought to be achieved by all these legislations that I've referred you to? Surely it does. There's no way one can arrive at a conclusion that says, looking at the vision and the mission of that document, it does not align. But then you have to go further on the authority of the insolvency practitioners case. It's the 2018 volume 5 SA 349. Particularly when you look at from paragraph, let me just have a look at judgment. Where it deals with the issue of the rationality of the paragraph 35. when it deals with legality. At paragraph 35, starting from, in fact, it starts from paragraph 33, when the chapter J deals with legality of the policy that was being impugned. He says, in the second concurring judgment of the Supreme Court of Appeal, Supreme Court of Appeal held that the impugned policy was in breach of the principle of legality because it omitted to direct the master to promote the interests of creditors when appointing provisional trustees. It was stated that this duty flows from the fact that the overarching purpose of the Insolvency Act is to protect and advance the interests of creditors. Whilst accepting that the minister formulated and designed the policy to achieve transformation, which is one of the objects of Section 158(2), the Supreme Court of Appeal held that the minister acted in violation of the principle of legality by not adopting a policy that is consistent with the overall purpose of the Insolvency Act. Then he goes on with the supporting statement at paragraph 34. The court will read for itself that part. But important in paragraph 35, he says, I disagree for two reasons. First, the expressly stated objectives of the policy are to promote consistency, fairness, transparency, and achievement of equality for persons previously disadvantaged by unfair discrimination. The attainment of some of these objectives, especially fairness, would advance the interests of creditors. What is important about this statement is you've got to look to the policy itself and test it with whether it achieves the objectives that it says it achieves. We don't test this legality and rationality in the abstract. And because I disagree with the document as it stands, I believe my definition of transformation goes from this point to that point. Because I disagree, because you have not covered my own terrain of what I understand to be transformation. I disagree with that and simply say that then it becomes illegal. It suffers from a legality defect. No, that cannot be. You look at what the policy itself says. Go deep into it. Tell us, in its purpose, vision, and what it seeks to achieve, does it then align with the purpose of transformation? That's what we urge you to do as this court. And he says in paragraph 36, second, when the master appoints provisional trustees under Section 18 of the Insolvency Act, the objective is to protect the interests of creditors. Once again, it goes deep into the document, the policy itself, to assess the policy, whether it aligns with that. We urge you to take a look at the legal sector code with the background that we have given you, to assess whether the legal sector code aligns with what needs to be achieved. You are told about higher percentages that are prescribed. But if you look at it in the context of the fact that we have been waiting as the people of South Africa for a transformed Norton Rose, for a transformed Weber Wednesday, for a period of more than 30 years. They've not done anything. They can only account for 7%. So, and the generic codes that we said, probably they are going to help you, Norton Rose and Weber Wednesday, to transform yourselves. Here are the generic codes, transform yourselves under them. Still, they yield the same result that we had in 1996.
Just to mention, the insolvency practice code, as far as I can recall, was struck down.
Yes, because not because of the irrationality related to the purpose of the document.
Yeah, because of the deficiencies in the code.
Exactly. No, I accept that. But in having said that, I directed you to the judgment to pick up how you need to deal with
Yes.
the assessment of the legality and the rationality point.
Mr. Matubesi, I do not know whether you are still. What is the status of statement 003?
Okay.
Must it be complied with, or what is your sense?
There is, firstly, the starting point is that every document that arises from a statute must have some force, because it is a document that must be obeyed. But the question is whether then the non-compliance with that document
Leads to invalidity.
must necessarily lead to a declaration of invalidity of whatever act that you have done. That's we must accept, because we are issuing these documents so that people can obey them, these people can comply with them. Otherwise, it wouldn't make sense for us to be given this power if we are going to issue them and we say to people, disobey them for only one.
Yeah, but that is, what would the consequence then be of not following
But
a guideline that has been, the minister has published?
But let's go back to understand what is a guideline. There's a difference between a guideline and a rule. The effect of those are different. A guideline is just a document that guides you to perform a particular act. It is not as obligatory as a rule.
And it
comply.
does not matter whether it utilizes derogatory language. Is it derogatory?
It takes us back to the same interpretation.
Peremptory.
Yeah, it takes us to the same interpretation exercise where I referred you to the Premier Eastern Cape.
Yes.
Because you need to look at what is the nature of this document, what is the purpose of this document. It is just a guiding document. So the use of a must or must it lead to an invalidity, taking into account the purposive interpretation of the document. It should not. That's the submission we make. It may be that we've made deviations where it said you must make deviations when you comply with A, B, C, and D, or D. But does that necessarily lead to an invalidity? We submit no, because you need to take it within the context of it being a guideline.
And may I just ask this? If it is only a guideline, why must deviations then comply with certain requirements, or why must that then be motivated?
It's because to some extent there must be consistency and a way of measuring the rationality of those deviations. That's why you would be told that you will deviate under these circumstances, because there must be consistency in the application of the guideline and in assessing compliance with it, and deviations, whether those deviations are justifiable in the circumstances where the deviations have been made. But it should not necessarily lead to a conclusion that says, because we have prescribed that there must be a deviation that is justified in a particular way, then it means that it is peremptory. Invalidity must follow if there's no compliance. That then would be getting out of what the Act envisaged when it categorized it as a guideline. Because the legislature could have chosen to say you must prescribe rules, but deliberately so it chose to say guidelines. So we must give effect to what the legislature had
And
intended.
those guidelines are only there to achieve the purpose of the act.
Yes. I don't intend to get into the details of the code. We have canvassed some of the details in our answering affidavit. We would urge the court to go there and have a look at the answering affidavit. on certain clauses of the code that we refer to in support of our case. The last, maybe on the interpretation exercise, the last topic that we will deal with
Because
is
interpretation is important in this matter.
yes, it is. Because if we are to achieve a just decision in the exercise of determining rationality, we must then engage in that process of interpretation. Otherwise, we are not going to be able to know the purpose of any clause and the purpose of any piece of legislation or secondary legislation if we are not going to engage in that exercise. So, but as I said to Justices, I'm not going to take you through the code,
No, I don't think it's necessary.
but we may just mention that we urge you to look at clause 7 of the code becomes important as well. The business case for the LSC. It goes deep into giving you a picture of what the intention of this whole code was.
Business case.
So we've made our point in relation to the general codes, that is statement 003, the binding effect of that statement 003. The submission we make in that regard is that statement 003 is by no means a peremptory provision that such that it declares invalid everything that done.
Should have been called guideline.
It's a guideline. That's why we draw the difference. We may just mention one important aspect on this rationality principle that we need to deal with. That new Africa duty-free judgment, paragraph 113 to 114. The court, if the court were to, at its own time, have a look at what Matopo J says in relation to the rationality test. In particular 114, where he says, in this case, the question to be asked is merely whether there is a rational connection between the quota system, including the process followed in adopting the system, and a legitimate purpose. The aim of the rationality test is not to determine whether some means will achieve the purpose better. It is limited to an assessment of whether the selected one could also rationally achieve the same end. Courts may, therefore, not interfere with the means selected simply because they do not like them or because there are better means that could have been selected. Rationality concerns the relationship between the exercise of a power and the purpose for which the power was granted, and requires no more than that decisions must be rationally related to the purpose for which the power was given. Put differently, there must be a rational connection between the means chosen by the decision maker and the end sought to be achieved. This includes the adoption of a rational procedure. And he says rationality is not about justification, nor is it about the cogency of reasons furnished for a particular decision. It concerns the question whether there exists a rational connection between the exercise of power and the purpose sought to be achieved through the exercise of that power.
Well, that's interesting, this last sentence. So there need not be cogent reasons
It's not
as long as
concerned.
there's a connection.
Yeah, it says that it's not concerned about that at all when you talk rationality. Should not be concerned about whether these reasons that are given are cogent or what. You simply have to look at whether it will achieve the purpose that we want to achieve. And we make a point in our papers that in any event, even if you were to find that there are minor defects in the code, because no document, no legislative instrument has ever been perfect, especially a legislative instrument that looks in the future. Because remember, when we enact legislations, we enact legislations with the hope that in the future they are going to achieve good results. You must keep that in mind when you are considering the rational connection between the means and the ends. Take into account the fact that this is created now, but it is created for a future. So you can't achieve perfection in that instance, because perfection only arises where you've got the benefit of hindsight. Then you can be perfect. But if you are creating a document now that is going to be there for the next 10 years, you must give allowance for the fact that that document may never be perfect. That's why the Act itself gives you gives the minister and the stakeholders a right to amend as they go with the code, because it might not necessarily address
Or achieve.
it the way that everybody would want it to achieve. But just look at whether it is directed at the purpose, and it has got the potential to achieve that. Not it perfectly achieves that, because you can't be able to predict the future. So the point is that that's all that you are required in the threshold of rationality, is to simply look at that, not a perfect document. So we make that point and say it's got a potential of not being so perfect, but realizing that it is a document that looks into the future, then we must leave room that it may not be perfect, and there are means that are made or that are designed for purposes of dealing with that imperfection in it, if it comes out to be imperfect.
So this is definitely not a partial review. It is a legality review.
They argue both, but we do submit that it is not. If one looks at their case, it is not a partial review. It is a legality review, and it is a rationality issue, and whether then they go to partial, but the test is not going to be that different.
Well, the test
Because that's
partial is wider.
Yes,
Is
it
if
may
I
be.
understand it
It may
correctly.
be.
Legality, the court is
Yeah.
there's a limit. The test is stricter.
It may be, but bear in mind what Kampempe J said in Bapedi Mamane, that we have referred you to say you don't seek to find a perfect administrative action, even under Paja Section 33. You don't seek to find that. Whether there's a better way of doing it, you gotta defer and say that's the person that was given power to do that. He has adopted a document that looks in the future. It serves the purpose because there's a connection between what he wants to achieve and what he has designed. So that's all that we need to look at. There is an attack on the lack of a transitional period in the code. We submit, as my learned friend has submitted, that the fact that there's no transitional period is really a product of the guideline. Firstly, the guideline says there shall not be a transitional period, but in any event, the legal sector code itself recognizes in clause 38.2 that whoever has been assessed during the period of the coming into effect of the legal sector code will be assessed at the end of the financial year of that assessment. That once the certificate expires, then that's when he's going to be subjected to a legal sector code assessment. So that there's no transitional period is really of not a good point. It's without merit. It can't invalidate the code. So the next point we make is in relation to section 9.2 argument that they advance. The Van Heerden argument.
Haven't we dealt with that? Is that
we
9.2
9.2 of the Constitution.
of the Constitution?
Yes. the Van Heerden argument. They say to the extent that the code is meant to be a restitutional measure, it does not comply with what is required by Section 9.2. We submit that all that Van Heerden requires for a restitutional measure to pass constitutional muster, and therefore insulate the state organs from attack, is that firstly, the measure must target people or a category of people who had been disadvantaged by unfair discrimination. We know the code in its own terms targets those people that are disadvantaged by unfair discrimination. The second is whether the measure is designed to protect and advance such people. We know it is designed to advance such people. But there's an argument being advanced here which suggests that the exemption of 95% of legal enterprises in the code defeats or is a clear indication that the second requirement of Section 9.2 is not met. We submit that there's no merit to that argument. On their argument, they accept that those entities that are exempt are those that earn an income that is annually that is less than 5 million. And they say, because they are exempted, then it means it defeats the entire purpose of transformation. That cannot be correct. We are dealing with economic transformation here. That we must keep in mind. And economic transformation means economically you must uplift those who have been discriminated. You transform them and uplift them. If you are going to put measures that suggest or prescribe that people who earn an income of less than 5 million must have 50% of directors within a period of 2 years, those 50% of directors in them must come and share that 5 million. They must be white, black, Indian, coloreds. They are coming to share the 5 million, which is the threshold for that amount. Where's economic transformation there? Instead, you are saying to them, go and club together and suffer. That's all that you are saying. So it can't be a good argument at all. It just can't be a good argument. That's why we're saying that transformation is not necessarily about numbers, the economic transformation. It's a composition of a lot of things that needs people to understand the dynamics that inform.
Not only percentages.
Yes, it needs someone to be wider than a narrow approach of saying we are here dealing with 2 blacks, 1 white. That's not what we're dealing with in transformation. Especially when we now come to a point where we're talking economic transformation. Because economic transformation means that those people who are being transformed must be able to get out of that door with at least something that they can show as a benefit out of the transformation, economically. Now you say they must come in and share a 5 million rand, and you expose them to the ratings and the tests under the code. That if you do not have a black person as a white person who's earning less than 5 million rand, then it means you are not transformed. Yes, it may very well be that, but does it achieve the objects of the economic transformation to say he must go and get three blacks to come and share the 5 million? Doesn't make sense. So we submit that's why we need to look at. The exemption is exactly because of that. There's a rational connection between that exemption and the purpose of the Act and the Constitution. And you don't need to get that from the minister. You don't need to get that from the stakeholders. You need to look at the code itself and interpret it as a whole to say, does it then, in these exemptions that it talks about, reflect a picture that seeks to achieve the economic transformation. That's all that we need to look at. And we submit that there's no merit to the point that it doesn't pass Section 9.2 requirements. The third requirement is that the measure must promote the achievement of equality. We submit that the code ticks this box as well. It may very well be that it will take longer, it will take shorter to achieve equality. We don't know, because it's looking at the future. But let's give it a chance. Because rationality says that we must give it a chance. We can't test it on an armchair basis and say, okay, because I don't like it, it's not going to achieve that purpose. Give it a chance, and let it show itself if it is going to achieve that purpose. But what you need
I'm quite sure the midwife will be very glad. She grows up well.
What only you need is to look into whether it promotes the achievement of equality, which we submit it does. So once more, the Section 9.2 test, the code passes the Section 9.2 test. So, Justices, I don't intend to deal in detail with the grounds of review that have been raised by the applicants. I think I've touched on those that are impacted by the submissions that we are making. We can't ignore the submissions that are made by the other stakeholders, simply because we are of the view that the decision that is being impugned is that of the minister.
Now, I hear you.
Because we are concerned here more about rationality and legality. So it's important that those who are tasked to do the job, to the extent that they have had an impact and a contribution to it, they must come and tell this court why they arrived at certain decisions, why they arrived at certain clauses of the code. It becomes very important, because what you seek to achieve is a determination of whether, on its true intent and meaning, the code is invalid. That's what you seek to achieve. You're not seeking to validate the reasons of the minister. Neither are you seeking to validate the reasons of the LPC or the Minister of Justice. You're looking at the code that was designed or drafted by a particular group of people. Then that code is the one that you are asked to test whether it passes constitutional muster and it is valid. So for that purpose, every contextual information that you need to get is important for your determination of that issue. I'm not going to be a champion for the underdogs, but I'm just mentioning that to say, to the extent that there may be an argument that says there must be excluded, I would not align myself with that kind of argument. There's issues that relate to solidarity. The minister also has opposed the application by solidarity. I know they have not advanced any further arguments than those that have been advanced primarily by the other applicants. But importantly, we don't abandon any point that we have raised in our heads of argument and in our answering affidavit.
So that will include a non-joinder point.
Yes, including the local standing.
Yes.
It's not the non-joinder, including the local standing, because we believe they were told in the AfriForum and the University of Free State matter how they like to interfere in matters that do not need them. For as long as they are going towards transformation, they want to interfere in those matters. So they were told in no uncertain terms that you gotta tell us what gives you local standing. to come to this. They raise the same
I think
argument.
that was canvassed.
Yes, they seek to raise the same argument and say our members, and you must point out who are these members. That's what the Constitutional Court said. You must point out who are these members that you're talking about, and what is their relevance to the issues that I played before this court. So that's what they were told in the AfriForum versus the University of Free State matter. They come again and do the same thing simply because they believe in transformation, but that's the reason why they are coming and interfering in this matter. So in conclusion, we say we are not abandoning any point that we have raised. All the points remain live for determination by this court. We are not going to go through them again.
Yes.
We conclude and say there is simply no merit in the applicant's case if viewed within the context of what we have given to this court. And importantly, this court is not going to have superior wisdom than that which the stakeholders that drafted the code and the minister that gazetted the code in exercising its powers. It is not a case of them having been correct or incorrect in what they have done. This is a review and not an appeal. And importantly, in a review, you must exercise some measure of deference and understand the limit of your powers in terms of the law and the Constitution. So to that extent, we submit that this application deserves to be dismissed.
No costs.
We don't argue for costs, but we leave it in your hands. those are our submissions, and I see.
That was perfect. It's 5-4. Thank you, Mr. Matabesi.
So maybe my junior reminds me of something, that there's an issue of remedy but we have addressed it in our heads of argument. We can simply refer you to the heads of argument and say the remedy we prescribed there, we still stand by it in the event you find the code.
It's helpful to have juniors.
I have actually 3.
Yes.
Those are our submissions, unless the court has got any questions on anything.
Yeah. No, thank you so much.
As the court pleases.
Let's just see what will be happening tomorrow. Fourth respondent.
I'll be starting the second respondent.
Yeah. Oh, are you going to start tomorrow, Mr. Mukoko? So you just switched. I thought you thought he will fight everyone's fight. No. So we'll start in with you tomorrow morning, Mr. Mukoko.
Yes, tomorrow morning.
Yes. Then the court will adjourn tomorrow morning.
That is